Okay, good morning. My name is Mark Brooker. I've been appointed by the Secretary of State to hold this inquiry into the appeal made by Fairfax Acquisitions Limited against the refusal of Hertsmere Borough Council to grant planning permission under Section 78 of the Town and Country Planning Act. The description for the development was outline planning permission, all matters reserved except for access for the erection of up to 195 new homes, 50% affordable, safeguarded land for the expansion of Newbury's primary school and provision of new medical centre along with associated access, landscaping and parking, and that was at land south of Shenley Hill in Radlett. Before I hear any evidence, I've got a number of practical matters to attend to first. I understand we haven't got any fire alarms planned today. If we do, the exits back out the way you came in and down the stairwell. Toilets are again out there. I understand we can't leave any documents in the room overnight, but perhaps everyone's got their rooms sorted anyway. I do have a draft timetable to run through later, but I think that might be subject to change anyway. Appearances. Can I take details of those who wish to speak today, starting off with the appellant, please?
Good morning, sir. I've handed you that sheet. On the last page of that clip, you'll see this set out. My name is Rupert Warren, King's Counsel, and I'm instructed by Boyer Planning on behalf of the appellant with my learned friend Dr. Bowes, Ashley Bowes, who sits immediately to my left. And we're going to call two witnesses, Claire Brockhurst, dealing with landscape visual effects in the Greenbelt, immediately behind Dr. Bowes, and Mr. Allen, Philip Allen, of Boyer Planning, dealing with planning, just to Ms. Brockhurst left. Thank you, sir.
Yes, good morning, sir. My name is Tom Cosgrove, King's Counsel. I'm appearing on behalf of the Council, together with my learned friend Mr. Clapp, who sits to my left, instructed by Mr. Stephen Stroud on behalf of the Council. And so I have two witnesses, and when you get our opening, you'll see them set out with all their qualifications at the back as well. But for present purposes, Miss Jacqueline Backer, who sits behind me, dealing with landscape and visual matters, and Mr. Stephen Stroud, who also sits behind me to my left, dealing with planning matters.
Morning, sir. Mr. Wayne Baglan of Council. I will also be calling two witnesses whose proofs of evidence you have. Claire Brown, dealing with issues of landscape and Greenbelt, and Valerie Scott, dealing with issues of planning and Greenbelt policy.
Any members of the public? Yes, good morning. Starting at this end.
Yeah, I'm just sort of coordinating.
It's essentially informally. It's not part of an organised group, neighbourhood group or anything like that. Okay.
They're just residents and councillors who wish to speak.
Okay. And yes, sir, you also wanted to speak as well?
Yes, I'm one of the residents who own a property that looks directly onto the...
Sorry, just your name at the present time. Thank you. Anybody else? Yeah, I'll start over the right. Yes.
I am Councillor Lucy Selby in my borough ordinance.
Thank you. Yes.
Yeah, it's a little bit unclear to me whether a list has already been provided to you for the local residents who wish to speak. But if you don't have a list...
I don't have a list at this time, no.
Then my name is Trevor Barton, and I am a local, very local resident of the proposed development.
Thank you. Yes, sir, at the back.
Christopher Langdon.
Yes, thank you.
Rosamond Gray.
Thank you. Yes, Madam there. Thank you.
Rosemary Gilligan, Chair of Shenley Parish Council, the adjacent parish.
Thank you. Yes, at the back.
Graham Taylor, resident and neighbour.
Anybody else? Yes.
I'm Helen Jones, Chair of APC, but I will be reading a statement on behalf of Estelle Samuelson as she is unwell. She was the chair of the Radlett Neighbourhood Fan Steering Group.
Okay. Thank you. Yes, sir.
Mark Rubinson, I will be making speaking on behalf of Stephen Rose. Unfortunately, can't be here today.
Okay. Thank you. Yes.
Sorry, no, I might be speaking on behalf of Councillor Caroline Clapper. She's coming from meetings.
Okay.
If she can't get here, then I will speak on her behalf.
Yes.
Sorry, there are a few other people that haven't been brought up.
Sorry, I don't understand.
There are a few other residents who want to speak who haven't actually been brought up.
They're down in reception, you mean? Yes, okay. Thank you. Yes, sir.
Richard Garrett, local resident.
Okay. I don't know if any more are going to be coming up yet. Do we know if all residents have been able to access the building? Or am I going to be waiting on others?
Would you like the other names?
Do you have a list? A printed list would be quite helpful if you have that noted down for me.
As I can get on to
That would be most helpful. In situations like this, when there are a number of residents who want to speak, what I would normally do is ask you to appoint essentially a spokesperson, and that could then address the inquiry on behalf of a number of residents who often want to raise quite similar issues. So rather than hearing the same issue 6 times, you essentially are able just to hear that issue once and understand that it's on behalf of a number of local residents. Now, clearly, I've been able to read all of the representations that have been submitted to me, both in respect of the application and then the appeal as well. So I don't necessarily need repetition of that again, but I do want to make time to hear from you today, but I don't necessarily want to hear repetition or hearing the same points from multiple people. That doesn't carry a greater weight before the inquiry. Have you appointed a spokesperson, or would you be able to appoint a spokesperson? Or would you wish to address me individually?
Excuse me, sir.
Yes.
I have helped organise, and I'm very aware that probably the last thing you need is repetition. So we have tried to keep the numbers low, and for each, whilst I couldn't guarantee no repetition, each to have particular topics for everyone's benefit, if that helps.
Okay. I'll leave you to organise yourselves then. We'll try to keep that down. If you need any advice from the council, I'm sure they can perhaps help and step in there as well. Okay. Do we think there are any other local residents who haven't yet been brought up from reception?
And the worrying thing is, I think when someone was phoned in, we were told that actually we couldn't come to this meeting, so I hope that hasn't happened to everybody.
I don't know why you would be told that or where you have heard that from, but clearly a number of you are here anyway, so that suggests to me at least the correspondence has gone out. You're saying you were told you weren't able to attend?
I may have misunderstood
No,
that.
I was told there's no procedure as to register our interest in just listening. So
Okay.
we've just,
If you want to turn up, it's a public inquiry, you're welcome to attend.
but we went somewhere else.
Yeah,
So anyway,
okay.
there was no one else downstairs and we were there.
Grant, thank you very much, that's fine. I notice everyone's made it here as well. Okay. Thank you very much. Are we being live streamed today? I did see a note of that on the documents page. Is there any
We
recording?
are, I'm told.
Is that recorded,
Probably.
or is it just live
I
streamed?
think it is.
recorded.
And what we have to remember and what we will do internally is when you break for a lunch or an adjournment, we'll tell the person who will sometimes be sitting up there, but he's not at the moment, but we'll WhatsApp him to stop the recording.
Okay.
You have to be slightly careful of what you're saying. Just a warning for everyone, or maybe not be careful depending on what you're saying, but just in those moments of relaxation between breaks.
Of course. So is everybody happy that it's being recorded? No one wants to be excluded from that? Happy? No, happy. Local residents, Rule 6. Thank you. Okay. For everyone's information, I held a case management conference on the 16th of December with representatives from the appellant, from the Rule 6 party and from the council. It was held to discuss the procedure for the inquiry. We didn't go into the merits of the appeal, and the note of that conference should be available on the council's website. Yeah, thank you very much. And notification letters, as I mentioned earlier, I have copies of the council's letters of notification, and I'm satisfied the interested parties have had those as well, and they're here. And again, as I said, representations, I've had copies of those representations. The appellant's happy that they've had all copies of representations as well. Thank you. Plans, I won't go into the plans at the moment, but I understand there's no particular dispute to the plans. I haven't got any additional plans before me, and as requested, you gave me a list of the plans that will be approved, essentially the plans I'm making a decision on, and that was agreed between the parties. Thank you. In that case, documents and late evidence, I'm not inviting any, but does anybody have any late evidence or additional documents they want to submit to me? No, Mr. Warren, confident shake of the head there. No. No. Any local residents going to want to submit documents to me?
I sent something last night, actually, which hopefully got to you.
No.
Okay.
No, unfortunately not. What document was that you sent through then?
So basically, my objection, I was actually going to read something out here, but actually we've got enough speakers and there might be some duplication, but I basically wanted to say that.
Okay.
I live next to the grid, so I actually have quite good overview.
No problem. After we've gone through the opening statements from the parties, I'll have a short break to give the interested parties the opportunity to put their heads together for 10 minutes, agree on their topics of what they're going to speak on and who they want to speak, and if I can then get that list from you, we'll be able to run through that afterwards and before lunch.
May I just check one thing on documents, sir? We had our instructing solicitors prepare a short note just introducing the obligation, and that indicates, I hope helpfully anyway, where there's still a bit of debate between the parties on, I think that was yesterday. I could see Mr Cosgrove nodding. Council, I hope the Rule 6 party have got that as well. I just wanted to check so that it had made its way to you.
I don't think, again, I haven't received that document. If that was just quite recent, I haven't received
Yesterday.
quite a great deal of documents this week, which was reassuring and helped me prepare well for it, but I might well see there's something coming, is there?
It was sent yesterday. We'll make sure we've got a hard copy, sir, but it's for the 106 session later on in the inquiry.
Okay. So I think just on that, it's very helpful. We've seen the latest draft. I think it was yesterday. We haven't seen the note yet, but that sounds like a very sensible thing to have. You'll also need from us a civil compliance statement, which you haven't got yet, and that will be imminently arriving with you. I think, I'll look behind me, I'm going to say tomorrow, if that's all right, once we've got the finalised to you.
That's fine, thank you. Okay. And as we touched on at the planning conditions and obligations, I do have a list of the suggested conditions, which I presume interested parties have also had the opportunity, I will come to you in a moment, to look at those conditions as well. They're essentially based on the conditions that were in the officer's report when it went to committee. So you should be reasonably familiar with those. And we will have a roundtable session. Again, it's without prejudice. It doesn't suggest that I've made up my mind or the council has conceded their case. It's a normal part of the appeal process to go through those conditions that would be applied if the appeal was allowed. And we'll do that as a roundtable session and a discussion later, and do familiarise yourself with that document as it comes through. And I would like additional drafts of that to be made available to the public.
So yes, if I can help, it's core document 6.17, I think. So that will be on the council's website if people want to look at it.
Thank you.
There, and that's, I think, agreed between the main, well, certainly agreed between the appellant and the council, I think.
Okay. Do local residents understand that there is a copy of the planning obligation that the appellants would enter into if the appeal were allowed, and you can see that on the council's website, the core document reference 6.1.
Sorry, that was actually the conditions, sir.
Conditions.
I don't think the unilaterals made it on because they were last minute drafting points. But
if that could be made available to local residents, I'm keen that that discussion takes place within the public domain, not least because I do follow when fellow inspectors get a judicial review or challenge, that it's helpful that that is made public, that discussion. Yes. Particularly the content and the outline of that debate as well.
The copy that was sent over yesterday to Ms Skinner and to the other part, to the main parties, along with the note that was sent with it. So we'll just liaise and make sure that goes up today.
Thank you very much for that. Thank you, Mr Cosgrove, Mr Warren. Thank you. Okay. And then the proof of evidence, obviously I've had copies of those and you can take those as having been read. Thank you for submission of those. And indeed the statements of common ground as well, both the planning and landscape. That's very helpful. Thank you for the efforts of the parties to produce those. So procedural statements, I'll just run through this very shortly because we have got quite a compact timetable. I think almost quite a challenging timetable as well based on the timings I was given. So we're running through opening statements today. I would like to hear from the third parties as well if possible. I would like to try to do a site visit. I have familiarised myself with the area, but I haven't done, if you like, a formal inquiry site visit where local residents will be welcome to attend that site visit where I will walk around Radlett. I will see the suggested itinerary from parties, or if people are happy, I can go and do that by myself. Sometimes that can work better, but I do appreciate that local residents like to see me seeing the site, but so that everybody is aware that is purely the purpose of the site visit, is for me to see the site. We won't have any discussion on site, and everything will be agreed before we go out on that site of what I'll be looking at. Ideally, we'll do that, and we are, despite January being out the way, daylight hours are still somewhat challenging in that respect. Then perhaps hear from the council's landscape witness today, if there is time available. Then we'll run through the Rule 6 landscape witness before the appellant's landscaping witnesses. Before moving to the rest, there was my draft timetable on the council's website. I don't think I had actually seen it. It is, so people kind of had sight of that. Thank you. So Wednesday we'll be doing landscape for Rule 6 party and for the appellant. Thursday, generally planning, and indeed even Friday, running on to the appellant's planning witness, conditions, obligations, then closing statements, and somewhere in there we'll shoehorn in a site visit. Okay.
Yes, can I just raise one quick point on that? So I think on the one that we've got on the website at the moment for today, we've got your introduction, the openings, members of the public, and then Miss Backer. Did you want to go and see the site today, if possible, before we get to the formal evidence, if you like?
Yes, so as we discussed, I think at the CMC, that I did do a preliminary site investigation, which is what we generally will do. I'll go out and familiarise myself with the area. I didn't go onto the site, but I did have a look around Radlett and from the road to and from it. Very much so has been outlined on that draft site visit itinerary. So I have an idea of what the area is, the lie of the land, but I would like to do a formal site visit. And ideally, I would do that before I hear any landscape evidence. And indeed, I had been trying to exercise this inquiry timetable quite a lot because I didn't really want to do a site visit halfway through one party's landscape evidence and before another party's landscape evidence. I felt that wouldn't be necessarily the ideal. So given that we've got perhaps a reduced number of interested parties, we can see how perhaps we get through this morning, and if needs be, I can spend at least part of my lunch break to go and do that formal site visit, depending if interested parties wanted to come along for that site visit or not. If I can't fit in today, I can't, in which case I will wait until I've heard all of the landscape evidence before I try to fit in a site visit again. And if needs be, I will come back at a later date to do one at the end of closings. And that may well be just what we have to do.
I mean, we're totally in your hands, so we couldn't organise it for today, if that turns out to be what you'd like to do, sir. Absolutely, we're in your hands on that.
And from what I understand, the site is essentially a field, and so I don't necessarily need to get a significant level of access to the field. I can just walk around it. There are no health and safety issues on that site. As I look to local residents, would you want to attend a site visit if I did an accompanied site visit?
Could I please come? And also, is it possible to please do it by both foot and by pavement?
So, yes, by foot and by...
I'm saying that because actually it's on quite a sharp bend, and actually I oversee the potential accidents I hear constantly screeching along there, and I think unless you drive it, you won't realise how sharp that bend is. And also you need to walk it, because actually, you know, talking about things like GP surgery potentially, or anybody walking down there, it's quite a dangerous route if you're taking a pram, or if you're elderly to walk there, so it does actually make a difference.
Did you see the sort of suggested site visit itinerary that was circulated by the parties?
No.
No. So there was one essentially that suggested both a driving and a walking route, Mr. Cosgrove.
Yes, it's called document 619 on the website, 6.19. I think it's pretty much the last document on the list, if that helps.
I'd love to be there if that's okay.
So yes, I can organise an accompanied site visit as best we can, and I'll leave to the parties if you have a particular suggestion of when you know your cases as well as I do, better than I do. If you have a particular opportunity for me to do that site visit, I'll take it for you. We're quite close to the site, at least we're 10-15 minutes away, so I could even do that relatively quickly. Do you have a particular suggestion then when you want me to do the site visit?
And so I can see your point of not interrupting and doing it after one landscape and before the others. I think just to be particularly unhelpful, you either do it before it or you do it after it all.
Fine. If we can get through it today, I'll stop talking. I'll let you get on with your openings. We'll try to put it in before this afternoon's session, if that's okay with everyone. And yes, local residents can attend. Yes, sir.
Could I also...
Okay, that's a very useful point to raise. I can do a site visit quite happily in the afternoon, and I could do an unaccompanied site visit for myself. So when I came past the site yesterday, I came through what I would generally consider to be peak rush hour. I can also, as I have done other site visits in the past, particularly arrange it for school drop-off, school pick-up times if needs be, something like that. But I think I can go through and yet use that sort of peak rush hour time, and I don't have to do it within the inquiry. I'm quite happy to do an unaccompanied site visit to pick up particular points like that, morning rush hour, afternoon rush hour, whatever needs to be. But if I can go out and do that this afternoon before I hear the landscape evidence, I'll be very grateful to be able to do that. Thank you. Okay. Is everybody happy there? Are there any other particular points anyone wants to raise with me? Yes?
Would you like the list?
If you've got a printed list, that would be most helpful. Thank you. Do the parties would like a copy of that? Would be helpful to have a copy of that? Printed list, yes. If you could hand that, Mr. Cosgrove, if you could organise that, a photocopy of that for the parties, that would be most helpful. Thank you. Fine, okay, thank you. Thank you then, Mr. Warren. When you're ready with your opening statement, please. Thank you.
Yes, certainly. So you and some others have got a copy of this to hand. I'm going to read it out and it'll be on the website, I hope, later on today for those who haven't got a hard copy in front of them. These are the appellant's opening points, sir. In this appeal, the appellant seeks permission in outline for up to 195 homes, 98 of which would be affordable, with safeguarded land for a new medical centre and expanded primary school facilities. The background is a really serious housing shortfall. Against a national policy to boost significantly the supply of homes, Hertsmere has slipped further from the target. Since the previous appeal on this site in January 2024, the market housing shortfall against Hertsmere's requirement has more than doubled. The housing delivery test, HDT, results have gone from 102% in 2020 to only 46% in 2023. The current agreed land supply position is only 0.98 years, which translates as 4,868 homes short of the housing requirement. So behind those figures are the social effects. Only 49 on average per year, that is, as you can see, net new affordable units have been delivered in the period 2012 to 2024 in Hertsmere, and only 6, that's an absolute number, only 6 in total in this parish over that period. It's one of the least affordable places in the south of England to live. However, the resulting lower quartile rents in Hertsmere are 84% higher than the national average, and the average house price in Hertsmere has risen 10% faster than the national average from 2012. So to meet this clear local need for market and affordable homes, the council promoted a plan in 2021 through which it intended to allocate the appeal site for 195 homes with 40% affordable, in common with other Greenbelt sites. The council, however, decided to restart its plan making, but has yet to undertake consultation on a new draft plan. So the collapse of the plan making process in relation to this site was not based on the council changing its mind that the site was an appropriate place for 195 homes to be built. Against that backdrop, if permitted and developed, the appeal site would make a prompt and meaningful contribution to the shortfall in market and affordable homes, as well, as I've said, as provide land for the school and the medical centre. There is the undisputed evidence from Carla Homes that you have, sir, that they would anticipate the first units being delivered in May 2028, assuming an approval in April of this year. That contribution and its acceptability in planning terms was recognised by the council's officers when they recommended the appeal scheme for approval. However, as you know, members refused permission. The single reason for refusal discloses that there are no technical or non-Greenbelt reasons to withhold planning permission for the provision of homes. Radlett is a key settlement, second only to Boreham Wood, Potters Bar and Bushy in the settlement hierarchy. The wide range of services and facilities in the town and outstanding public transport links by rail and bus means that it is unsurprisingly common ground with the council that the site is a sustainable location. So I just turn now to the evidence briefly under the main issues. And on Greenbelt's main issue number 1, it's common ground with the council that the scheme passes all elements of paragraph 155 of the MPPF. And it follows, so that if the site were grey belt, then it would be appropriate development with no harm to purposes of openness of the green belt brought into account and no need to demonstrate VSC, very special circumstances. The Rule 6 parties case, that the scheme would not meet the golden rules, we say so is unsubstantiated. The suggestion that the scheme would fail to deliver the necessary infrastructure is unsupported by any evidence, nor indeed the relevant consultees. Moreover, sir, the argument that the proposed area of public open space would not be satisfactory because it wouldn't contribute positively to the landscape or support nature recovery finds no support in the policy wording, even if it were a good point in substance. So both elements, we say, of the Rule 6 parties case in this respect are therefore unreasonable and shouldn't have been pursued. But the focus of the debate on grey belt is whether the site performs strongly against purposes A and B, given that there is no dispute that the site doesn't make any contribution to purpose D. The council doesn't allege that the scheme would fundamentally undermine the Greenbelt in the rest of Hertsmere, or that there are any, sorry to use the jargon, so footnote 7 issues which prevent the site being properly classified as grey belt. There is a national objective to assess and identify grey belt sites. As the planning policy guidance, the PPG, explains, where existing plans or assessments don't identify grey belt, it's expected that decision takers consider existing evidence by reference to the grey belt tests. And here, so the pre-existing evidence is unambiguously clear that the site does not perform strongly against purposes A or B. First, sir, the council's green belt assessments did not identify the site as performing strongly against A or B. It's common ground that this evidence, which underpinned the previous emerging plan, which, as I've said already, draft allocated the site, remains a material planning consideration. Secondly, sir, there's then the site-specific assessment by your colleague, previous Inspector Mr. Fagan, in 2024. He found that the development of the site would have only a moderate effect on purposes A and B. Thirdly, sir, there's the evidence of CSA environmental, the appellant's evidential basis, which found the site made a weak contribution to purpose A and no contribution to purpose B. Fourthly, there's the assessment of the council's own officers, who concluded the site did not perform strongly against A or B when recommending this scheme for approval. And then, so fifthly, officers took the trouble to engage independent legal advice from the barrister who represented the council at the 2024 appeal. He advised that on the evidence, an inspector was very likely, having regard to that evidence, to conclude the site was grey belt. So the evidence which has been submitted to meet the appeal hasn't disturbed the cogent conclusions of those prior independent assessments. As Miss Brockhurst will explain, the highly enclosed nature of the site, the visual relationship to the existing urban edge, and the significant separation both in geographical and perceptual terms, which would remain between Radlett and Boreham Wood, are all inescapable facts which render any conclusion the site performs strongly against purpose A or B unsustainable. So I turn to main issue 2, sir, character and appearance. I note, though, sir, first that it's common ground with the council that there is no standalone landscape reason for refusal. It's also the case the council's landscape consultee did not object to the scheme on either landscape or visual effects grounds. It's agreed that the site doesn't fall within a valued landscape to which paragraph 187A of the MPPF obviously would apply, and that outside existing settlements there are a significant number of other designations which would constrain the location of new housing, none of which affects the delivery of homes on this site. There's no suggestion, sir, the landscape effects stray beyond the site itself. Given the final landscaping details would remain in the control of the council at the reserved matter stage, the landscape issue in this appeal comes down to the loss of the pastoral land use. However, sir, as I've said, given the harm is highly localised and confined to a field on the edge of an existing settlement, the weight to attach to the loss of that landscape resource should be given commensurate weight. Moreover, the lack of a landscape reason for refusal, indeed, sir, you may have seen this, landscape wasn't even mentioned in the Planning Committee's resolution to refuse permission, coupled with the fact that the council were content to allocate the land for 195 homes and the self-evident need to develop undeveloped sites of this nature to meet anything approaching the very large shortfall, we say, sir, they're all further material considerations which bear on the weight to attach to the loss of the existing land use in the overall planning balance. As for visual effects, the case is even weaker, we say. The post-development views would either all be in the same view of existing housing or be part of a kinetic experience which included the existing urban area. The promoted walking route around Radlett already takes in the urban area, and the appeal scheme would be a very small part of that overall experience. So I turn, sir, finally to the planning balance. If the site is grey belt, sir, I think this is right, no party, no main party, suggests permission should be refused. So no, not the council nor the Rule 6 party. And so that's clearly correct. Even if the site isn't grey belt, though, there would remain a highly compelling case to grant permission. The agreed package of benefits against the context of a long-standing and worsening housing supply delivered on a site with no other objections in a borough which inevitably requires Greenbelt to meet its need, we say would amount to very special circumstances which would clearly outweigh the harm. And so we say that this is an obvious site to meet an acknowledged significant need. The findings of the previous inspector alone demonstrate the site amounts to grey belt, which the government, since that time, obviously, has specifically introduced as a policy response to increase the supply of new homes. The absence of any other grounds to withhold consent and the significant benefits the scheme would bring mean that permission, we say so, should be granted without delay, and in due course we will invite you, sir, to allow the appeal. Thank you.
Thank you, Mr. Cosgrove, when you're ready.
Thank you, sir. Yes, I think just copies have been passed out. Thank you. So the proposal is for a large-scale residential development in the open countryside and in the Greenbelt in circumstances where a materially identical scheme has recently been refused on appeal, as you will know. For obvious reasons, the prevailing practical and policy position is hostile to such schemes. Nevertheless, without making significant amendments to the prior failed application, the appellant now applies and indeed appeals once more. The root of the appeal is that the appellant considers national policy to have altered such that its previously unacceptable development might now achieve permission. The argument, as we understand it, is essentially that the site now falls within the newly minted definition of grey belt, meaning that development in the green belt may be permissible there. Whether the site falls into this category is not a matter of rigid classification, but of judgment. A proper examination, considering the important role this particular site plays in landscape terms, reveals that the informed judgment is that this site is not grey belt. Accordingly, the proposal remains inappropriate development. There remain, in our submission, no very special circumstances to justify the scheme against that backdrop. The benefits do not clearly outweigh the harms this scheme would bring forward. Now, as last year, the proposal should be refused. So by way of background, the instant proposal is, as you heard, for outline permission for substantial residential development and accompanying affordable housing outside the settlement boundary of the town of Radlett in the Greenbelt. The application was submitted on the 20th of September of 2004 and was refused in October 2025 based on the reason for refusal, which we set out there and I don't read out. The present application is essentially unchanged from a previous application at the same site, save for the level of affordable housing and matters relating to land safeguarded for a medical centre. That previous application was refused by the Council's Planning Committee, and an appeal against that refusal was dismissed by Inspector Fagan on the 26th of January 2024 following a 6-day public inquiry. Importantly, the inspector found the scheme would have a significant adverse effect on greenbelt openness and found that the proposal was, quote, in direct conflict with policy. Rightly, that decision is agreed to be a material consideration in the determination of this instant appeal before you. So what we do is just set out briefly our case, first of all, in respect to the main issues that you identified at the CMC in your note. But just in essence, our case is that the appeal should be dismissed because, firstly, in relation to the Greenbelt, the scheme is an appropriate development. The only route to avoiding that conclusion is by the application of paragraph 155A of the MPPF. However, that paragraph is only available for sites which are grey belt for the purposes of Annex 2 of the MPPF. A site may only comprise grey belt if it does not strongly contribute to purposes A, B or D of para 143 of the MPPF. And in this case, proper and fulsome assessment of the site confirms that it contributes strongly to both purposes A and B. The site performs, in fact, a vital role in forming a softened edge to the settlement of Radlett, and development there would represent further sprawl into the Greenbelt, whilst obviously reducing the physical and perceptual distance between Radlett and its neighbour, Boreham Wood. Secondly, there are no very special circumstances. The proposed scheme would give rise to landscape and visual harm arising from the introduction of substantial built form into a landscape which presently functions as a critical buffer by virtue of its openness and transitional relationship with the surrounding countryside. Its loss would result in significant adverse effects in landscape terms, to which substantial weight should be afforded. To that high level of harm will be added definitional harm, as the scheme is inappropriate in the Greenbelt, and further harm is also caused to Greenbelt openness by the proposed introduction of development in an otherwise open site. Those matters properly also attract substantial weight. It is acknowledged that the scheme would bring forth benefits, principally related to the delivery of housing, but in our submissions you'll hear that those benefits do not outweigh, still less clearly outweigh, the threefold package of substantial harms identified. And in relation to national and local policy, well, for the reasons we set out, national policy directs that the scheme be refused, and there would be conflict with the development plan policies referred to in the reason for refusal. Accordingly, the national and local policy position is that the proposal should be refused, applying section 38(6). In terms of just a short bit of detail for opening, in terms of the inappropriate development in the Greenbelt issue that you identified, the recent insertion of 155A in the MPPF appears the only possible route to avoid the conclusion that the scheme is an inappropriate development in the Greenbelt. The application of the test is contingent on the scheme comprising Greybelt, which is itself an assessment depending on the site not strongly contributing to purposes A, B or D within 143. And so, as you'll hear in our evidence, and will be explained by two experienced landscape experts appearing at this inquiry, and indeed, I should add, two independent experienced planning experts, the site does strongly contribute to purposes A and B, with the inevitable consequence that the scheme is not Greybelt, cannot therefore fit within the exception within 155A, and therefore must be regarded as inappropriate development. And so if I just interpose there, you note in Learned Friends opening, para 11A to E, they set out a number of considerations of people and persons that have looked at this matter. We'll address, and you will have said, we'll address each of those in turn and explain why, viewed in context, they provide no assistance to the appellant's argument. In relation to purpose A, the site strongly contributes to checking the unrestricted sprawl of large built-up areas. The proposed development would comprise sprawl, as Inspector Fagan found, and contrary to prior assertions to the contrary, that sprawl would form a, quote, large built-up area or town in, would be from a large built-up area or town in Radlett. The Council will explain the valuable role the existing site performs in providing an existing soft edge to the settlement of Radlett, facilitating a smooth transition between the lower density development at the existing relatively verdant settlement edge and the adjacent countryside. In short, the site is part of an existing functional boundary which presently prevents further sprawl. The loss of that functional boundary would only encourage further development to follow. On purpose B, the site strongly contributes to preventing neighbouring towns merging into one another. The appeal scheme reduces the physical gap between Radlett and Boreham Wood to just 1.36 kilometres, and the loss of the verdant, softening urban edge which the site presently provides would critically erode the feeling of distance between settlements. The site would result in a more expansive and unbuffered Radlett with less space at the settlement edge. It would be perceived by receptors as a settlement materially closer to its neighbours. The site therefore establishes not only distance between Radlett and neighbouring towns, but also performs a specific landscape role in ensuring that distance between settlements is understood and the discrete identity of local towns is preserved. It follows, so, in our submission, the scheme is an appropriate development in the Greenbelt. Substantial weight should be afforded to this definitional harm, in addition, of course, to the substantial weight afforded to the harm to openness, which inevitably arises and is discussed further below, applying 153 of the MPPF. In relation to the main issue 2, character and appearance, well, as we say, the site is a coherent open pastoral field, including surrounding woodland, which forms part of the rural setting of Radlett. It does have a specific and important character, which draws on its openness and its relationship with the surrounding woodland blocks and the verdant settlement edge, thereby performing a transitional role between the countryside and the settlement of Radlett. In our submission, the appellant overlooks much of this, pressing the fundamentally mistaken view that the site is more part of the townscape in Radlett than of the wider landscape. That approach to diminish the site was attempted, you will recall, before Inspector Fagan. He provided clear reasoning in rejecting it and indeed criticised the appellant for adopting an analysis, quote, overly coloured by influence by proximity to the housing on its western boundary. The appellant now apparently wishes to rerun that argument whilst acknowledging that little has changed since the previous appeal. Failure to appreciate the baseline position of the site is a foundational one, which skews the appellant's ability to appreciate both value, so the appellant's own expert appears to accept her view on this point is unlikely to be accepted by others, we give you the reference, and susceptibility, thereby leading to an erroneously depressed sensitivity analysis. The previously criticised errors in the calculation of susceptibility, principally the lack of clarity as to how this topic was evaluated, similarly appear to have been repeated. The dramatic and adverse impact of the proposal on the character and appearance of the appeal site is obvious. It's a point which was clear to Inspector Fagan, quote, the site's intrinsic character would be substantially adversely affected by the development. And it is a point which, so we think, should be clear to you when you go on site. The proposal is to install large-scale built development in place of an open field, currently facilitating this perceived soft edge of Radlett. This will be visible to a series of receptors, particularly within the first 15 years of the scheme, and it's right that this harm be afforded substantial weight in the balance. We will also, in due course, touch on some of the methodological shortcomings in the appellant's approach to appreciating the effect of the proposal in landscape terms, which further undermine their conclusion on impact and weight. And so that above analysis feeds in this case, into the position in respect of impact on openness. The change of the site would be fundamental from open and undeveloped to occupation by a large-scale and extensive built form. Accordingly, again, Inspector Fagan was justified in concluding, quote, the loss of 8 hectares of greenbelt land to built development will clearly have a significant adverse effect on its openness, which would be a physical manifestation of its inappropriateness. Once again, that conclusion is accurate, and the harm to openness must attract substantial weight. Main issue 3, it follows from our position on main issue 1 that it will be necessary, in our case, for the inspector to consider whether very special circumstances are present It's not the first time an inspector has approached that question in concert with Inspector Fagan, so we will demonstrate that the benefits do not clearly outweigh the harms identified, in particular here noting that the previous inspector concluded that he would not find very special circumstances, quote, even if greater weight was to be attributed to some of these benefits, as, quote, the totality of these other considerations would still not clearly outweigh the overall harm that the development would cause. It is common ground that this proposal would bring forward many of the standard benefits one would typically expect to see with a housing scheme of this type. Much will likely be made, in particular, of the importance of the delivery of housing, given the current exhortations of national policy and the existing shortfall in the borough. Yet those benefits, important as they are, do not prevail in every instance and fall to be weighed as a matter of judgment against the harms which would arise here, and they are extensive. It will cause definitional harm, as we've mentioned, to the Greenbelt, harm to openness. Those matters must be afforded substantial weight, as national policy requires. Further, substantial weight should be afforded to the landscape and visual harms we identify in evidence. Each of those matters is a powerful indication that permission should be refused, and taken together represent a persuasive package of harms which militate against the grant of planning permission. They are not outweighed, let alone clearly outweighed, by the benefits of this scheme, and as a result, there are no very special circumstances which would allow this development in the Greenbelt. It follows that footnote 7 is engaged, and there is a strong reason to refuse this development. So by way of conclusion, we say it's inappropriate development in the Greenbelt, and can only hope to achieve planning permission if the very high threshold of very special circumstances is met. The benefits of the scheme do not outweigh the weighty and extensive harms identified, and for that reason there are no very special circumstances, and the direction of national and local policy is that permission should be refused. We will invite you in due course, sir, to dismiss the appeal. And then you've got the list of appearances, as I promised, at the back.
So, sir, thank you. These are the opening observations on behalf of Aldenham Parish Council, the Radlett Society and Save Hertsmere. And so, by way of introduction, we submit that by the second appeal, the appellant again seeks permission for substantial residential development of up to 195 homes, expansion space for Newbury's primary school, and a new medical centre with associated access, landscaping and parking. What I've called the proposed development, or PD, on land south of Shenley Hill, Radlett. And the authority decided to refuse the application for the reasons set out in the decision notice. You've seen that within the core documents. The Rule 6 parties support the case contained in that reason for refusal and are providing expert evidence on the issues of landscape by Ms Claire Brown and planning by Ms Valerie Scott in support of that case. The Rule 6 parties also advance related points on, amongst other things, whether the development will be in a sustainable location, if, where applicable, the golden rules are satisfied, and the weighing of the case in very special circumstances. Now, the land comprises 11.45 hectares of greenbelt land on the southeastern edge of Radlett. The majority of the site is an agricultural field. None of the exceptions to it being greenbelt apply. It is not grey-belt land. It is not in a sustainable location, and in any event, it does not satisfy the golden rules. It's not allocated for development, and so very special circumstances are required to justify this development. And as we know, very special circumstances will not exist unless the potential harm to the greenbelt by reason of inappropriateness and any other harm resulting from the proposal is clearly outweighed by other considerations. It is for the appellant to show the test is met. As recently as the 26th of January 2024, Inspector Fagan concluded that the appellant's proposals did not meet that high threshold, and there is no reason to reach a different conclusion on this occasion. A number of substantial harms arise from the proposed development. They include definitional harm to the greenbelt, harm to spatial openness, harm to visual openness, harm to 3 of the 5 purposes of including land in the greenbelt, namely A, to check the unrestricted sprawl of large built-up areas, B, to prevent neighbouring towns from merging, and C, to assist in safeguarding the countryside from encroachment. In addition, the proposed development causes substantial landscape harm. Harm by visual impact also arises. The proposed development will undermine the site's contribution to the Watling Chase Community Forest. Residents of the 21 dwellings that back onto the land in Newbury's Avenue, Williams Way and Shenley Road will have severely affected amenity. The overdevelopment will preclude LNRS improvements. And so I turn first of all to the issue of greenbelt land. The whole of the site is designated greenbelt. Definitional harm, harm to openness and harm to the purposes of the greenbelt are clearly established by the evidence. And as we submit, the land is not grey belt. In order to meet the definition of grey belt land in the MPPF, the land must not make a strong contribution to, as relevant, purposes A or B of the land being in the green belt. However, this rural site does make a strong contribution to both of those purposes. In terms of urban sprawl, the site is of significant size and will demonstrably cause the sprawl of Radlett. It is adjacent to a large built-up area, it is presently free from development, and does not have detracting features. In addition, it reads as clearly rural, associated with the countryside. The minor roads and commercial plantation will not provide substantial permanent physical features containing further development. The plantation at Newbury's Woodland is reaching an age where the trees are likely to be felled, and there are already large areas of deforestation that appear to have occurred recently. Development of the land will cause an incongruous spread of Radlett in light of the quality of the land, the nature of the surrounding transitional development, and the creation of a large triangle of open land to the south of Theobald Street. In relation to Purpose B, the situation has changed significantly on the ground with the grant of permission on the 2nd of October 2024 for the Organ Hall Farm development on Theobald Street, Boreham Wood. That is a development of 110 dwellings and associated development. From the edge of that development to the edge of the land is in the order of 900 metres along a 40-mile-per-hour road. On any view, the land forms a substantial part of the remaining gap between Radlett and Boreham Wood, as well as the gap between Radlett and Shenley. As noted above, it is presently free from development and does not have detracting features, and it does read as clearly rural. And in that respect, Inspector Fagan made particular observations at paragraphs 20 and 21 of his decision letter, to which we've attached certain emphasis there, but so I don't read those paragraphs. You'll have read that decision already. But to note, those observations are the other side of a coin of making a strong contribution to those greenbelt purposes. If development on a parcel of land would render ineffective the greenbelt policy, that is because a strong contribution is being made to its main purposes. In his decision, Inspector Fagan acknowledged the value of the site to those two purposes, as well as to Purpose C, and it was not necessary to his conclusion to consider whether either Purpose A or B made a strong contribution. The concept of grey belt simply did not fall to be applied, and he did not have the benefit of professional evidence on the application of the grey belt guidance. It is entirely likely that, on that basis, he would have recognised the site making a strong contribution to both purposes. At that stage, the distance under consideration between the two main settlements was 1.7 kilometres to 1.4 kilometres. At now less than 1 kilometre, it's already been reduced by the order of 40 to 70% from that range. The importance of the inspector's observations remain today, and the contribution made to Purpose B is all the greater, employing the logic the inspector himself used in paragraphs 20 and 21 that I've set out above. So I turn next to the Golden Rules. The Golden Rules are designed to achieve high standards in relation to those exceptional cases where non-allocated greenbelt sites are to be developed. For example, they require 50% affordable housing. They also require accessible, good quality green spaces. The site wholly fails to provide spaces of such quality, which should, amongst other things, contribute positively to the landscape setting of the development and support nature recovery. An overarching issue facing the site, effectively unrefined from the last occasion, despite the clear advice of the local planning authority's place services, is that of the quantum of development. The illustrative proposals show that around 8 hectares of the site will be developed for the new homes, medical centre and access roads. Seeking such a high level of development has caused a raft of issues in relation to what is proposed. It is not landscape-led. It has a density and a layout that fails to reflect the settlement pattern and character of Radlett. In Radlett, the average number of dwellings per hectare is 11. The nature of the residential development in the vicinity of the land is clear from a cursory view of the surrounding roads. In stark contrast to this, the proposed development seeks to accommodate 36 dwellings per hectare, a level of overdevelopment that is wholly inappropriate. The proposed development offers poor green space provision. There is a lack of functional green infrastructure through the site. The green amenity spaces, play area, and sole usable amenity space are poorly located and appear as leftover areas rather than being informed by the landscape strategy. Poor connectivity of routes for active travel, contrary to the vision and proposals of the Radlett neighbourhood plan, are another issue. And the site will read as overwhelmingly suburban with an enclosed character. There will be adverse changes to various elements of the landscape, including substantial adverse effect to the overall site. The evidence of Ms Brown demonstrates adverse impacts to each of the 6 landscape receptors identified in the LVIA. Consistent with that, Inspector Fagan found substantial adverse landscape effects on the site as a result of the permanent residential development of 8 hectares of it. On analysis, the sustainability of the land is also in question. It is acknowledged that the land is located on the edge of Radlett, but paying particular reference to paragraphs 110 and 115 of the framework, one needs to consider the distance of the site from the centre of Radlett, the lack of local facilities, and the unsatisfactory pedestrian and cycle links to access the shops, service and railway station in the town centre. So for those reasons, the proposed development is not on grey-belt land and in any event does not comply with the golden rules. It causes substantial landscape harm and harm to visual amenity. I turn more briefly to other harms because the substantial harm to the landscape has already been recorded in our opening above. Part of that harm is the proposed development undermining the site's contribution to the Watling Chase Community Forest, and in addition, we have noted the development causes a level of visual harm. The characteristics of the development as described above will also preclude the enhancement of neutral grassland habitat to meet nature recovery objectives. And so moving on to the application of the very special circumstances test, it follows from the above that is for the appellant to demonstrate that the VSC test is met, there is very little by way of additional benefit beyond that relied upon by the previous scheme. And for the reasons set out in detail in the evidence of the authority and on behalf of the Rule 6 parties, the substance of the position remains the same now as for January 2024. The appellant fails that test. Accordingly, allowing the appeal would be in conflict with key provisions of the National Planning Policy Framework. And finally, and by way of checksum, we draw attention to the nature and extent of conflict with the development plan, because drawing all the above features of the proposed development together, the evidence from both the authority and the Rule 6 parties demonstrates substantial non-compliance with the adopted development plan. That evidence shows the overall development approach is contrary to various policies in the core strategy and the Radlett neighbourhood plan, including policies CS 12, 13 and 19 from the core strategy, from the site allocations and development management documentation, policies 3, 11, 12, 26, 27 and 30, and in relation to the neighbourhood plan, policies HD 3, 5, 7, RV2 and GA1. And so, sir, in light of all of those factors and the nature and extent of the conflict with the plan, we will invite you in due course to dismiss the appeal. Thank you.
Thank you, Mr. Beglin. Now, I had suggested we could have a short break to allow the interested parties to organise themselves. I'll see on this note you've provided me already that you do have topics already set out for people on here. Do you need 5-10 minutes just to organise yourselves? Or are you happy with...
Well, the order has changed, just apart from that, it's fine.
I understand. And you've noted on here that a couple of people couldn't attend today but wanted to attend later in the inquiry, and I'll try to make time to hear from them as well at the beginning of the day when that occurs. Thank you. Yes, sir.
Sir, I've just been told that when people speak without a microphone, there's certainly no live stream and probably not being recorded. So
Okay.
I realise the back of the room is more difficult, but I thought I should make you aware.
Thank you. I thought people had used their microphones, I'll be quite honest, but I hadn't noticed that. We'll try to endeavour to use our microphones. Thank you. Okay. So that was a no, we don't need a short break. Is everyone happy to carry on? Yep, thank you. Okay. So before I hear from interested parties, I think I'm right in saying that the local MP, Sir Oliver Dowden, had actually submitted a letter and asked that that be read out. So rather than myself doing that, I wonder if I can volunteer one of the interested parties, or perhaps Mr Cosgrove, to read that letter out. Do you have it to hand as I just throw that out? Okay.
Or to read anything out before I know what it says, but I will do my best if I
No, it's fine. We'll have a short break. Sorry, yes.
I actually have the letter, which I was going to ask you at the end of my speech whether you'd like me to read it out.
Ah, well, there you are.
We'll save Mr Cosgrove. But have you not had a copy of that?
No, I haven't actually.
The appellant's had as well. Right, my apologies for that. It obviously should have been sent on to you. It has made it that far. Okay. That's fine. Would you like to have sight of it before we carry on? You're happy? Okay. In that case, yes, I'll take you up on that kind offer that you can read it out at the end of your session, if that's okay. Or indeed, we might start with yourself and start off with a letter from Sir Oliver Dowden and keep him happy. Actually, that's fine. Okay. Thank you very much. So then, if I'd like to have you down here onto the witness table, I'll ask your name and then we can shortly hear from you. I don't wish to prejudge anyone here, but just from my experience at a recent event, if we could avoid applauding, groaning, I'll be quite honest. Someone delivered a beautifully timed groan last time. But if we can avoid that, just because this is a neutral venue, and indeed it's my venue, that I'd like to keep as neutral and as friendly as possible. Even all the way down to the front, if you wouldn't mind, so that I can get a proper look at you without changing my glasses every 2 minutes. Thank you. No problem. And you have some water down there if you would like some water. Okay, so I'll start off, I'll take your name, but would you be happy to accept any questions from any of the main parties who might like to ask you a question?
If I will try and answer.
Thank you very much. Okay, so we're going to start off with your name, please.
I'm Councillor Lucy Selby, and this site is in my ward, Aldenham East. Thank you. I sit here today for the 4th time representing nearly 2,500 residents of Radlett who objected to the proposal to build on this site. But let me yet again repeat the main points of objection. 1. This site is greenbelt land. 2. The next issue is whether this greenbelt land can be classified as greybelt. Section 143 of the MPPF states that greenbelt serves 5 purposes. One is to prevent sprawl. As you will hear, this is sprawl, and indeed is intended to be just the start of further development sprawl of the northeast boundaries of Radlett. 3. Another purpose is to prevent neighbouring towns merging. As the previous inspector found at paragraph 30 and 31, this proposed development would have a significant adverse effect on checking unrestricted sprawl and preventing towns from merging into one another. And this finding was made without knowing about the Organ Hall development. 4. With the Organ Hall development, there will be just 0.58 miles between the two sites' planning boundaries, and so that previous inspector's finding carries even more weight. These two developments would inevitably lead to the merger of Bournemouth and Radlett. 5. This is all why my fellow councillors legitimately and reasonably determined this site is not greybelt last year. 6. In any case, section 155 of the MPPF is not met in full. The proposed development does not meet the requirement of sustainable location, and it follows paragraph 116 is also important here. Development can be prevented because of the unacceptable impact on highway safety or the residual cumulative impact on the road network. We all know that Shenley Hill is a very narrow country road where buses and cars cannot pass, and that the access point to the site is on a bend just by the crash barrier that has now mysteriously disappeared. How can this be deemed safe when there has already been a loss of life? 7. If you take account of the build-up of traffic on Shenley Hill that happens already, and then allow for at least 2 cars per household that will come with the additional 195 homes, plus delivery vans, it is plain that paragraphs 115B and D are not met. 8. Further, paragraph 117D of the MPPS states the need to allow for efficient delivery of goods and services and emergency vehicles. There is only going to be a single point of access for such matters, which is not acceptable for such a large estate. 9. Planners can depart from advice from the Highways Authority. As the court found in Shadwell Estates Limited versus Breckland District Council, the views of statutory consultees are given considerable weight but are not definitive. They can be departed for cogent and compelling reasons which clearly exist in this application. As was clear from the LPA's meetings, the Highways officer was not aware of the damage to the crash barrier, which is, as I said, disappeared. He also conducted his survey during school holidays. He has not undertaken any further studies, and most importantly, he is ignoring the feedback of the people who actually live in the surrounding area, and more of which you will hear later. In addition, section 155D refers to the Golden Rules. Golden Rule B requires necessary improvements to local or national infrastructure. This is not satisfied. Lord Banner, in his opinion at the recent LPA determination, said it can be satisfied by a suitable SIL contribution. However, he also says that if a suitable contribution is insufficient, Golden Rule B can be met on account of land being safeguarded for a new medical facility and expansion of Newbury School. This is unconvincing. How can the provision of land for the purpose of providing infrastructure actually amount to an improvement to local infrastructure? There is no improvement to infrastructure until the infrastructure has actually been provided. We also know that Red House Surgery has no intention of moving to this site, away from their current position in the centre of Radlett, and which would go against the Radlett Neighbourhood Plan. 12. Golden Rule C is also not met. How can a small piece of land classed as a playground on the junction of Shenley Hill by the disappearing crash barrier really satisfy the requirement for new or improved existing green spaces that meet residents' needs? This is a big decision for you, sir. The planning balance is in your hands to make the decision. We can see from all the 2,500 plus interested parties in Radlett, the public interest is in this appeal. This decision matters to the people of Radlett, as shown by their local representatives being a Roll 6 party. We have fought this since 22, and we will continue to fight it. Please make the right decision as for the 3 previous attempts to develop this site. Thank you very much. Then I can move on to...
Thank you, and the letter from Sir Oliver Dowden, thank you. You're going to read that? Oh, so you have
yes,
more. No, sorry, I didn't want to interrupt. I thought I was you saying you were finished there.
I was going to read right
yep.
on.
Absolutely fine, thank you.
Okay. Oh, it's quite small print. Dear Mr. Brooker, I'm writing regarding Fairfax Acquisitions proposals to erect 195 homes on the land south of Shenley Hill in Radlett. He then gives the reference. I'm contacting you in my capacity as Member of Parliament for Hertsmere, as many constituents continue to contact me with deep concerns on this matter. I agree with residents who believe that if the development goes ahead, it will have a detrimental effect on the area. I would therefore like to formally register with the Planning Inspectorate my opposition to the proposal as part of the representations you consider on this appeal. Residents have always also conveyed to me their fatigue of having to object to this application after objecting to the developer's previous application on the same site, to which no substantial changes have been made. You will be aware that Hertsmere Borough Council rejected the developer's previous application, as did the Planning Inspectorate on appeal. This was a decision that many residents and I welcomed. We also welcome the Council's decision to refuse the most recent planning application. I have lobbied to protect our precious greenbelt land. This includes by holding the government to account on the revised National Planning Policy Framework and the farce of Greybelt being used as an excuse to tarmac over perfectly legitimate Greenbelt land, such as land south of Shenley Hill. I've also asked questions in Parliament regarding the Golden Rules, which I do not believe have been met in this proposal. The site does not meet the definition of Greybelt, as I and many residents believe it strongly contributes to the purposes of the Greenbelt, especially to check the unrestricted sprawl of large built-up areas and to prevent neighbouring towns merging into one another, namely A and B of the MPPF paragraph 143. Development on this site would allow Radlett's further sprawl, and it would reduce the gap between the towns of Radlett and Boreham Wood. If this appeal is granted, applications would be granted that reduces the gap until there is barely a separation. This is before taking into consideration other planning applications that would also reduce the gap. Separately, on the Golden Rules, the proposed development does not confirm necessary improvements to local or national infrastructure. In this case, land to be allocated for a medical centre is not guaranteed, especially as NHS England, Hertfordshire and West Essex ICB is unable to support the delivery of the new medical centre on this site for viability, affordability and deliverability. Red House Surgery have also stated they do not want to move to the site, and this proposed site goes against the Radlett Neighbourhood Plan, which states that medical services should remain located in the centre. For these and other reasons you will have heard, I believe the site should be regarded as Greenbelt and not Greybelt, that very special circumstances do not exist, and the appeal to be dismissed. If the planning inspector disagrees and grants the appeal, this will open the floodgates for speculative applications that will have to be granted. Hertsmere, as we know it, will be gone, and a precedent will be set across the country that neutralises the traditional protections of the Greenbelt. I apologise that I'm unable to attend the public inquiry due to prior commitments, but I would like to reassure residents that I will continue to fight to protect our green open spaces that make our area so special. Yours sincerely, the Right Honourable Sir Oliver Dowden. Thank you.
Mr. Warren, do you have any questions?
I don't.
Do you make a policy of asking questions of the interested parties? I
don't really have a policy. What I normally say at this point, sir, is that if I'd like to, I kind of pipe up.
Okay.
So I'll do that if I see fit. Thank you very much.
Thank you.
So I know, that document I now have, do you want that to become an inquiry? What's your practice? Do you want that to start an inquiry list of documents?
I think that would be helpful, yes.
And make that number one. And I'm just conscious also if there are a number of people about to speak with documents, written documents that you may not have seen, we could of course make copies given a few minutes so we all have copies rather than... People may have brought copies with them or they may not have anything they want to read, but administratively and then we give them numbers as we go through.
Yes.
If they're different from what they've written in. Yeah.
I was going to say a lot of the time it tends to be sort of duplication or representative of what they've already submitted. If there's anything additional to change in there, then yes, I would take that. It would be helpful. Thank you. Thank you.
So I've just been reminded, so we perhaps make the openings 1, 2 and 3, and then that can be 4, and then I'll let someone else take it from there.
Thank you. I think that would be quite helpful, and we can have that in the
yes, absolutely. Provided the parties are copied in, that's absolutely fine. Yeah.
Thank you. Yeah. Thank you. Okay. We're already on to the next one. Thank you very much. We're going to take your name, please.
Good morning. My name is Caroline Clapper, Councillor Caroline Clapper.
Okay. Thank you. And again, if you're happy to accept any questions that Mr. Warren may have for you, that's most helpful. Thank you very much. Okay, when you're ready, thank you.
Thank you. Good morning, Inspector, and thank you for the opportunity to speak. As I mentioned, my name is Councillor Caroline Clapper, and I'm the Hertfordshire County Councillor for this division and also a Borough Councillor for Aldenham West. I appear today to object to the proposed development on the land south of Shenley Hill. This is not a new proposal, nor one previously found acceptable. It has been carefully examined, refused, appealed and dismissed. The earlier decision was clear. The harm to the Greenbelt was substantial and the benefits did not amount to the very special circumstances required to justify inappropriate development. What has materially changed since that decision is the policy context. Hertfordshire's local nature recovery strategy was formally launched only last week. It now forms part of the strategic framework guiding how land should be used across the county. Newly adopted policy is not symbolic. It is intended to shape real decisions starting immediately. Plans and strategies only retain credibility if decision makers are prepared to give them full effect once adopted. The key issue here is fundamentally a local one. The strategy requires the identification of specific locations where nature recovery should be prioritised. Shenley Hill is one such location. The mapping that underpins the Hertfordshire strategy clearly identifies this site as a site for environmental enhancement, particularly the strengthening of woodland and grassland habitats, not their removal. Put simply, land identified for nature recovery should not be simultaneously considered suitable for large-scale development that would permanently undermine these very objectives. I am concerned that the proposal appears to make little, if any, meaningful reference to this newly adopted strategy. At the very least, the absence of clear engagement with it is striking, given its relevance and timing. Hertfordshire has taken a significant step forward. Sorry, bear with me 1 second. Hertfordshire has taken a significant step forward in adopting this strategy after extensive evidence gathering and public engagement. It would be deeply unfortunate if, at its first real test, it were afforded limited weight. I therefore respectfully ask that the local nature recovery strategy be given full and proper consideration in the planning balance at this appeal. The strategy is explicit in its ambition to reverse nature decline, strengthen ecological networks, and use land strategically to support long-term environmental resilience. That ambition depends on protecting connected landscapes rather than allowing their incremental erosion. Greenbelt land performs an increasingly important dual role, preventing urban sprawl while also providing the scale of land necessary for meaningful nature recovery. Once released to development, these opportunities are not reduced, they are lost permanently. Turning back briefly to the Greenbelt, the previous inspector concluded that the proposal would cause significant harm to openness and to the purposes of the designation. That defining harm has not been resolved. Adjustments to housing mix or safeguarded land do not alter the central planning balance if the fundamental conflicts with the Greenbelt remains. Very special circumstances must be exactly that, genuinely special. If a proposal substantially similar to one already dismissed were now approved, the obvious question would be, what has changed significantly to justify a different conclusion? Respectfully, very little appears to have done so, aside from a policy landscape that now places even greater emphasis on environmental protection. There is also the question of certainty. Promised infrastructure carries limited weights when delivery depends on future agreements. Harm to the Greenbelt, by contrast, is immediate and irreversible. This site currently contributes to openness, rural character, and wider environmental network. Once developed, that contribution is gone forever. This is not an argument against growth. It is an argument for directing growth to the most sustainable locations while respecting the policies that we have only just put in place. The local nature recovery strategy reinforces something that communities have long understood. Land is not simply available until it is built upon. Some land is strategically important precisely because it remains undeveloped. Approving this appeal would not only erode the Greenbelt, but risks weakening the authority of a county-wide strategy within just days of its adoption. For those reasons, Inspector, I respectfully ask that the appeal be dismissed. Thank you.
I haven't got any questions. So no, thank you. Thank you. Is your name Councillor Gilligan, was it?
I'm Helen Jones.
Helen Jones, right.
So, as I mentioned, I am the chair of APC, the Rule 6 party, but I'm speaking now to read a statement from Estelle Samuelson, as she cannot attend. And she was the chair of the Radlett Neighbourhood Plan Steering Group. So I'm afraid if you have questions, I can't answer them, but I would be willing to take questions and try and get answers to you as quickly as possible.
Thank you.
Thank you for allowing me to address you at this inquiry. I do so as chair of the steering group of the Radlett Neighbourhood Plan and not in my capacity as a parish councillor. As you are aware, the Radlett Neighbourhood Plan was adopted at referendum in May 2021, designed to present a vision for the future of Radlett until 2036. The plan took many years to produce, not least because of the COVID pandemic, and was the hard work of many members of the community as well as local councillors and professionals. It is now an important document which forms part of Hertsmere planning policy and as such needs to be used to help make planning decisions. Therefore, I am somewhat surprised I am sitting here again today at yet another appeal about a possible housing development on this particular piece of Greenbelt land, as it goes against so many of the Radlett Neighbourhood Plan's policies. In particular, policy RV2 medical services, which clearly states that any such facility should be located in the centre of Radlett with its vibrant high street, 2 pharmacies and parking facilities in Hertsmere's public car park, which is situated just across the road to the existing Red House surgery, where it has been located for many decades. Moving the GP surgery to a location almost a mile further away, up a steep hill, away from everything, including the retail shops and restaurants, could also have a detrimental effect on the local economy, with its diverse role of uses and services. The retail footfall in the high street would be severely reduced if a GP surgery was no longer positioned centrally. To reach a medical facility on the Shenley Hill site, it would inevitably mean taking your car there. This would result in extra unnecessary vehicle movements, and for those without a vehicle, a difficult walk for the disabled, elderly, or those seeking medical attention. Since the last appeal, a working party was set up to ascertain whether any of the possible sites identified in the Radlett Neighbourhood Plan might be a suitable place for a new medical facility in the future. With that in mind, meetings have taken place with the partners of the Red House surgery over the past month, and they have indicated that at the moment they are able to cope in their existing building with the number of patients they have on their books. Therefore, this is giving us time to research other sites in the centre of Radlett, within the vicinity of the High Street, and liaise with other developers about possibly incorporating a new medical facility in one of their schemes. Members of the working party are looking into the Royal Mail site, which the previous inspector identified in his report as being the most suitable as it is directly adjacent to the current Red House surgery. It is important to point out that the partners of the Red House surgery wrote to Hertsmere Borough Council in May 2024 withdrawing their support of the Shenley Hill development, as they wish to do what is in the best interest of the local community. And their stance has not changed, as confirmed in their email to Alderman Parish Council on the 9th of January 2026. The local community do not want a doctor's surgery in the position being suggested, away from all other amenities, transport infrastructure and the High Street. It is quite clear that the appellant's position is completely contrary to the policy in the Radlett Neighbourhood Plan, which the residents of Radlett voted for and is now established in law. I also should add that approval for development of homes at Organ Hall Farm in Theobald Street, which is just 800 metres away from the site that Fairfax Acquisitions wishing to develop, also incorporates a medical facility. Policy GA1, Getting Around Infrastructure, states that any development that reduces the quantity, functionality and or quality of walking and cycle networks would not be supported. At the moment, one can walk along footpath 55 with a lovely view of the open countryside. Should this development be approved, that openness would be lost forever and therefore goes against the purpose of this policy. The leader of Hertsmere Council states in his letter to the Health Secretary that medical facilities are needed in Bushy, Bournemouth and Shenley Hill. Shenley Hill is not a town, it is a road in Radlett. Surely Radlett, with its thousands of residents, should be mentioned in the same way as Bushy and Bournemouth, especially as other possible sites in the centre of Radlett for a new medical facility are identified in the Radlett Neighbourhood Plan. I would therefore ask that when considering this appeal, the weight of special circumstances attributed to the medical facility in order to allow 195 houses to be built on precious Greenbelt land is given very little weight, if any. A site for a new medical facility in the centre of Radlett that is accessible for all has been very clearly adopted by the community through its Radlett Neighbourhood Plan, a fact established in law and with a clear democratic mandate. I thank you for allowing me to speak today. Estelle Samuelson.
No, that's fine. Thank you very much. Good morning.
Good morning.
Good morning. If you can remind me of your name, please.
My name is Rosemary Gilligan. I am... Is this working? It's on the left. Okay.
Thank you.
My name is Rosemary Gilligan. I am the chair of Shenley Parish Council, and the boundary of our neighbourhood plan and the Radlett neighbourhood plan is the woodland adjacent to this site. I spoke at the previous inquiry, which dismissed the previous application in January 2024. It does seem strange to me that an application which was dismissed in January came back as a new application in September. Nothing having changed in the application, and the new NPPF, which introduces the concept of grey belt on which this appeal relies, did not come into force until December 2024, 3 months after the application was submitted. We object to the application and support the case from Aldenham Parish Council as a Rule 6 party. They will be putting the main arguments for a refusal, but I am here to discuss the traffic issues on Radlett Lane, Shenley Hill, which will impact in Shenley Village, and request that, should permission be allowed, a condition is made regarding construction traffic to prevent it coming through Shenley. There is already a lot of construction traffic coming through the village due to further developments on the Sky Studio site to the northwest of the village and a development in the parish on the Bournemouth border. The roads through the village are narrow country lanes that cannot safely support the level of traffic using them. Radlett Lane, Shenley Hill is a narrow country lane with a number of very bad bends along the way. I am astonished to see the access proposed for the site as it is positioned near one of the bends. I'm sure experts will speak about that later. I have lived here all my life and used to compete with my horses at the now closed and redeveloped regional show centre at Patchett's Green, Radlett. Because of the narrowness of the lane and the issues with the railway bridge, I would never use this the shortest route. If you drive, as I do, a large horse box, the issues with the narrowness, bends, and people who do not seem to comprehend how to drive on rural roads, together with the many accidents over the years, make this road one I did not want to risk my horses on. Even without horses on board, my day-to-day vehicle is an ancient 4x4 from the days when they were large enough to accommodate everything rural life needs. Driving between Shenley and Radlett is not fun. You have to be aware that oncoming traffic often has to cross onto your side of the road to make the bends. Should, after the appeal, approval is given, because Radlett Lane is so narrow and unsafe for construction traffic, and the logical route from Watling Street up Shenley Hill is not available because there is a 7.5 tonne limit on the railway bridge, and that limit is because the bridge cannot accommodate heavy traffic. So we would ask for a condition that uses the lowest possible amount of 7.5 tonne vehicles for restricted access for a roadway for the construction access. I have the full suggested condition here with its detailed illustrated justification. This will be emailed to you for your kind consideration. The condition is to use the 600 metres of Shenley Hill adjacent to the site, not the 3 to 4 kilometres of 7.5 tonne restriction for access started with Radlett Lane from London Road, Shenley. Shenley Parish Council are happy to provide further information and be involved in discussing this condition. Thank you.
I think I'm right in saying we'll pick it up in the round table session, but there's a condition that covers essentially construction management plan and the like. Yeah, thank you. So we'll back that up. Thank you.
Okay. Thank you.
Good morning. What's your name?
Good morning. Thank you for the opportunity to speak. Rosamond Gray, Radlett resident for over 50 years, chair of the Radlett Society and Greenbelt Association, a local interest charitable group with a wide membership of the area. We believe Hertsmere's decision to refuse the previous development applications confirmed on appeal was correct. It is an inappropriate, harmful development in the Green Belt. This further appeal says the site is now Grey Belt. Whilst we recognise change of Green Belt policy, the introduction of Grey Belt, our view is simply that this site is not Grey Belt, as I will illustrate. Grey Belt was announced by the government as land that made limited contribution to the Green Belt, and in particular had some previous development. Secretary of State Steve Freed said in October 24, Grey Belt is areas people wouldn't recognise as green, disused car parks and petrol stations. The ministerial announcement introducing the revised National Planning Policy Framework in December 2024 described Grey Belt, parts of the Green Belt that contribute little by way of aesthetic, public access or ecology value. Looking at the Shenley hillside, it's never had any previous development. It's open countryside of prime quality. It has real ecological and nature value. The government's clear intention is to retain the Green Belt, but use Grey Belt to focus on land that makes a marginal contribution to it, particularly land that has had previous development. That is not the case with this site. It makes a very strong contribution and has never been developed. Additionally, and importantly, it makes a strong contribution to the clear space between Radlett, Shenley and Boreham Wood. A key Green Belt road is to prevent coalescence of settlements. With the approval of the expansion of Boreham Wood along Theobald Street at Organ Hall, it is even more vital that this site continues to contribute to the buffer between two towns. We would reiterate that, as an established in previous appeals, this application does not demonstrate the necessary very special circumstances to allow development in the Green Belt. It is unwarranted permanent sacrifice of 11 hectares of underdeveloped open green land. The claimed benefits are nowhere near sufficient to outweigh the harm caused. Yes, this proposal does provide housing and medical facilities, but as the Radlett plan, our local approved plan, sets out, what we need is local and affordable housing and expanded in-town medical facilities, not edge-of-town developments where none of the homes proposed are in reality are small and affordable. And Radlett has a medical centre in our centre that almost all can walk to. Why promote a new medical centre accessible only by car and away from existing pharmacies? The plans do not even include a cycleway. Thank you for listening to my comments. They reflect the concerns of our membership. The Green Belt is part of Radlett's attraction and people want it preserved. This is not Grey Belt, and we're strongly oppose this appeal on these grounds. Thank you very much.
Thank you. Thank you.
Rachel, who would like to speak tomorrow, if that's okay with you.
Is that Rachel Shaw that
Yes.
you'd identified on your list? Thank you. Okay. I'll try to make time for that then tomorrow. Is anyone else wanting to speak? Thank you. And your name?
Yes, good morning. It's Graham Taylor. Can you hear my microphone?
No. Might have to sit next, one seat over. Oh, thank you.
Right. Okay, right. I think we've been fine.
Thank you. If I can just pause you for one moment,
Yes.
just to reiterate again, because I know a number of people do want to speak, but if we can try to avoid repetition, particularly of issues that I've already heard previously. Thank you very much.
Yes, so I fully understand that, and I'm going to be editing this on the way. So thank you for allowing me a bit of time to speak. What are we talking about? We're talking about a small outlying field on the Woodhall estate, which is 600 acres in total. I noticed in the recent marketing of the whole estate that Savill speculated a development of nearly 2,000 homes. In the same brochure, the estate was described as productive farmland. Sadly, and you will see this yourself, sir, later on when you visit the site, it has been allowed to deteriorate. When normally it is grazed by sheep or producing hay, I argue that its present condition is not representative and should not be seen as justifying development. I will not talk about purposes A and B, which I've read, but if you will permit me, I would like to say a little bit about purpose D, which I think a lot of people have dismissed, but I think it's significant and offer relevant context as a trustee of the local museum. Now, excuse me, Arab's Green Belt report confirms Radlett's historic status. Through its centre passes a Roman road, Watling Street, a route that is at least 2,000 years old. Less than a kilometre from the field, a Roman pottery kiln was discovered in the late 19th century, with artefacts now displayed locally and in the Verulamium Museum. Furthermore, extremely rare geological pudding stone deposits have been found close to the application site. The land therefore makes a strong contribution to Purpose D through its historical, geological and landscape value. If I may now please turn to the affordable homes question, which are key to satisfying the golden rules. Such housing is seen as essential for those people whose needs are not met by the market, including essential local workers. Let's look at some figures. The average annual pay for junior teachers, police officers, nurses and resident doctors is around £34,000. Using the current market's average price of a semi-detached home in Radlett as £800,000, or a terraced home at £750,000, even with a 20% discount, would that be affordable? A 30-year mortgage at 4% would require monthly payments of nearly £3,000. Clearly unaffordable for local key workers, even on joint incomes. And what about lower paid workers? And where would these residents work? Where would they move to? Radlett is a lower employment centre, a lower tier employment centre, with most jobs located in Watford, St Albans or Boreham Wood. So this would lead to unsustainable commuting and trips. Consequently, it's likely that the Affordable Homes Golden Rule requirements would not be fulfilled, and therefore the case for the grey belt classification is unsupported. Finally, may I briefly address the claimed very special circumstances relating to additional land for Newbury School. As a former parent governor of the school and familiar with the school site, I do not believe that this land is needed. Existing play space is more adequate for this 7-form 210 pupil school. Even if the scheme were approved, the projected additional pupils would not justify an extra form of entry. Equally, I am confident of the adequacy of the existing play space, and I don't see the offer of playing field land can be used as very special circumstances. So in conclusion, I'm opposed to the loss of this site for the reasons given and for the irreversible loss of openness and harm to outlook, nature and wildlife. So on the grounds outlined above, I urge you to dismiss the appeal. Thank you, and I'm prepared to take questions.
Thank you, Mr. Taylor. I have no questions myself. No, thank you very much. Thank you.
Thank you.
Yes, please do. Thank you. Push to talk. Push to talk. There we go. Good morning.
Good morning. Hi, my name is Paul Booth. Thank you, Inspector, for allowing me to speak today. I'm not here as a planning expert or a developer, but as a parent, a homeowner, and a member of a close-knit community whose lives will be profoundly affected by this proposal. My family purchased our home in Radlett during the pandemic, seeking safety, stability and community. We chose this area because of its character, its peace and the open land that defines it. Our very small garden, like our neighbours, backs directly onto the proposed site. We have uninterrupted views across the field, which I have submitted photos of, and this view provides us with a sense of space and a connection to nature. Just for those of you in the room, this is a picture of the space that we have. And just the site is a valuable open space, serving as a buffer between homes and overdevelopment, and preserving the landscape that gives Radlett its rural character, while protecting residents from noise, congestion and visual intrusion. As a young family, the impact of this proposal on our mental health and well-being is profound. The open field provides light, calm, and a sense of space essential to family life, particularly for young children. The prospect of losing this view causes anxiety and long-term stress. The impact on our children and hundreds of others is significant. Our 3 children attend Newbury's primary school, which is adjacent to this field. Children learn not only in the classroom, but from their surroundings, and they'll be affected both at school and at home. We will endure years of construction, followed by a dense housing estate, street lighting, increased traffic, pollution, constant noise, and the loss of privacy due to overlooking. The calm and well-being currently provided by Newbury School will be destroyed. Our children deserve better. The appellant has not addressed the immediate or lasting harm this development will cause. For residents, the loss is deeply personal. Natural wildlife habitats will be destroyed and cannot be replaced through the inadequate landscaping. Traffic, noise, air quality will deteriorate to unacceptable levels, directly affecting children walking to school and the wider community's health. The strength of feeling within Radlett is clear. With an unprecedented 5,000 objections submitted for this and the previous application, this represents a considered response from a community that knows what it stands to lose. The scale of objections demonstrates that this development is fundamentally at odds with the character, capacity and wishes of the local area. From where we live and from where our children learn and grow, the harm is overwhelming and irreversible. Once this field is lost, it cannot be recreated elsewhere. I urge you to look beyond housing numbers and consider the real human cost of this proposal. The families who will lose their outlook, peace and privacy, and the children whose school environment will be fundamentally altered and a community that loses a vital part of its identity. This proposal does not benefit our community. Protect this land, this school and the community by dismissing this appeal. Thank you for listening.
Thank you.
Good morning, sir.
Good morning.
My apologies if some of what I'm now going to tell you you've already heard, but I was unaware of the fact that certain speakers were going to raise certain matters.
Can I just check your name then, please?
My name is Alfred Boyden.
Thank you.
I've lived in Radlett for 21 years, and I've been directly involved at the forefront of the construction industry for over 50 years on major infrastructure projects, excuse me, such as Canary Wharf, where safety, transportation and construction-related issues and their considerations should always be at the forefront of any decisions being made. The development site in Shenley Hill, which is a very narrow, windy road, has only one possible access route due to the 7.5-tonne weight restrictions at both ends of the road, namely via Watling Street, Theobald Street, Craigwell Avenue and Williams Way. Previously, this would have been possible via Black Horse Hill, Harper Lane, but due to weight restrictions, this is no longer the case. Other than Watling Street, these roads are not suited to cope with vast numbers of lorries required to transport the excavated material from the site to the muck chute in Coursers Road at Coney Fields. This available route also represents significant logistical challenges and raises concerns regarding road safety and congestion, as these residential roads are narrow and often lined with parked cars unsuited for ongoing heavy construction traffic. As a trained quantity surveyor, I have calculated that the removal of the topsoil alone from the 20-acre site requires a minimum of 3,000 lorries, with in all probability a further 4,000 lorries being required to remove excavated materials in relation to the foundations and other parts of the infrastructure. The increased number of lorry movements, including the delivery of materials, will compound existing traffic congestion, disrupt daily life for local residents, and pose considerable risks to pedestrians and other road users. Excuse me. The average road width is 5.4 metres, with a large tipper lorry being 7.9 metres long and 3 metres wide, effectively preventing two lorries from passing one another, thereby also causing the road to become blocked whilst travelling to and from the site during ongoing journey manoeuvres via the 5.5 metre wide entrance. Because of their width and limited manoeuvrability, the articulated load loaders, which will be used to transport plant and material to the site, will block the road for prolonged periods whilst being loaded or unloaded in a safe manner. In addition, the substantial number of contractors' vans and cars will have nowhere to park because this is a large site which will employ a large number of operatives. The rise in lorry traffic could also affect emergency services, local roads and community infrastructure, particularly during peak times. Another fact relates to the lorry wheels, which will inevitably deposit mud on the highway, causing a hazard to road users, particularly in wet weather conditions, with the slow-moving road sweepers, which will be required to clean the road, adding to further gridlock, as will the lorries having to wait on the road before eventually being permitted to enter the site. It is also unreasonable to impose the increased air and CO2 pollution from these lorries over an extended period, as this is considered as being detrimental both to the environment as well as the health of both their drivers and also the public at large. With respect, sir, I believe that the proposed large-scale development is inappropriate for the area, does not serve the interests of Radlett residents, and therefore should be rejected. Thank you for your attention.
Thank you. And again, these are many of the issues I'll raise in the round table in respect of conditions as well. That maybe some of those issues could be dealt with by condition or addressed by condition. Thank you.
Thank you.
Good morning, sir.
Good morning.
My name is Trevor Barton.
Thank you.
Again, a number of points have been made. I will simply speak to those points that I think require emphasis. Thank you for giving me the opportunity to speak. I have lived with my family on Williams Way, Radlett, very close to the proposed development site for 22 years. Previous applications and appeals by Fairfax Developments have all been rejected for very good reasons that have not gone away. Yet Fairfax keep applying and appealing, presumably hoping that they will wear down a system designed to prevent inappropriate development of the green belt. This, I would submit, should not be allowed to happen. This land is designated green belt, as reflected in local maps and policies. There is no dispute on that, and there are no factors which water down that designation. The land provides exactly what the green belt was designed to provide and maintain. A green barrier between built-up areas, stopping urban sprawl in an already very crowded part of the country. Now, I believe Fairfax are arguing that this is so-called green belt, which is a category of quotes unquotes less valuable green belt, for which there's no formal mapped designation. And as Rosamond mentioned, the current Housing Secretary, speaking when he was Environment Secretary, stated, and this is worth repeating, "We have been very clear about building on the grey belt. These are areas people wouldn't recognise as green." Complex planning reports are not required to define this land. It is a large green field in a rural environment. Any reasonable person standing looking at it would instantly recognise it as green. Furthermore, it is included in the local nature recovery strategy. Secondly, Radlett, as mentioned, does not have the roads to cope with a development of this size in this location, and I can assure you of that as a local resident who uses this road. In particular, access, both during construction and subsequently, would be a major and highly troubling issue. The Radlett to Shenley Road, as previously mentioned, and as you will see, is a winding single carriageway road. Residents currently living on the road have difficulty exiting their driveways at busy times of day, one car at a time. To build homes for another 195 families with an exit onto this Shenley Road near a sharp bend will compound an already major traffic problem. Fairfax commissioned a traffic study, but it was in August, during school holidays, thus completely, and I would say cynically, avoiding the issue. Should the development go ahead, I fear the residents of that development will be trapped in an enormous gridlock. Thirdly, a huge volume of objections have been lodged by residents at every stage, clearly evidencing massive local opposition to this scheme. In summary, I ask you, sir, to recognise the importance of preserving the green belt, to note my other submissions, and to reject the appeal. Thank you.
Thank you. I haven't got any questions. That's good. Thank you. Hello, good morning.
Morning. Yes, good morning. My name is Mark Rubinson, and I'm reading this out on behalf of Stephen Rose, who unfortunately can't be here today. So these are his words. I've been a Radlett resident since 1985. I spoke at the last appeal on the lack of very special circumstances for this green belt site, and I'm sure our parish council and its experts will again demonstrate why these do not exist. I offer only my perspective that the applicants are trying to justify that this site is grey belt. It is clear this land is not a disused petrol station or car park, as described by the Housing Minister when referring to grey belt, but almost 30 acres of green belt land. It is ludicrous for the applicant to claim that a key part of the site qualifies as grey belt simply because it is not unrestricted sprawl, because it supposedly lacks physical features in reasonable proximity to restrict or contain development. I also note that the site owner has recently attempted to sell the Woodhall estate while deliberately retaining certain parcels of land for future development. The sales brochure describes the estate as a strategic development opportunity and states that overage payments would apply to any future development. With this in mind, the woodland to the north-east is clearly not seen as a barrier to development or a means of preventing urban sprawl, as the sales brochure describes the land as having strong potential for future development, confirming the intention to further develop this green belt land. Radlett is under pressure from developers and the council seeking to meet housing targets. These targets must not be pursued at the expense of sound planning or by allowing developments on sites that are unsuitable or unsustainable. I am concerned as to why the letter written by the leader of Hertsmere Council to the Health Secretary in June last year blatantly advocates this particular site in his last paragraph, and why it is included in the applicant's Proof of Evidence Appendix 1. It contradicts Hertsmere's own planning policies and those of the Radlett Neighbourhood Plan. This smacks of political contradiction and interference, given the officer's insistence to approve the application. Regarding the video shown at the planning meeting last September, the case officer suggested it would take around 5 minutes to drive from the edge of the approved Organ Hall development to the proposed site on Theobald Street. This is totally incorrect. Driving at 40 miles an hour, the half-mile gap between these sites takes less than a minute. So if this is approved, Radlett would essentially be joined with Boreham Wood. The school expansion is not required, and the medical centre remains in the wrong location, despite comments from the leader of the council which contradicts the council's own policies regarding appropriate locations for such facilities. We must not be swayed by assurances or incomplete information, particularly when it comes to grey belt claims. As residents, we will remain steadfast in safeguarding our community and our environment, so please reject this appeal. Thank you.
Thank you. Good morning.
Good morning. My name is Christopher Langdon. Thank you for the opportunity to speak to you today. I've been a resident of Radlett for over 40 years. I'm retired. I'm a health walks leader and very familiar with the countryside affected by this proposal. The key issue is whether the proposed development is inappropriate in the Greenbelt and causes harm as concluded by the Hertfordshire Borough Council when it refused the application. The appellant has failed to demonstrate the very special circumstances required to justify development of this Greenbelt site. On the contrary, the proposal would result in significant harm, particularly arising from traffic impacts associated with 195 dwellings served by a single access onto Shenley Hill, which is already very busy and very hazardous. The Shenley Hill Watling Street roundabout is regularly congested, resulting in motorists using residential roads including the Avenue, Lodge End, the Drive, Williams Way and Craigwell Avenue, using them as rat runs. Watling Street is already operating beyond its capacity, with congestion not just at peak times but throughout the day. It is difficult to envisage how the existing highway network could accommodate the additional traffic generated by this development. School-related journeys alone could generate 800 vehicle movements per day. This excludes trips to local shops, delivery vehicles, service providers, gardeners, etc. In reality, the development is likely to result in several thousand additional vehicle movements per day, placing further strain on our already inadequate local infrastructure. As a pedestrian, it is difficult crossing the main road due to the traffic volume and the speed. This is exacerbated by the frequent roadworks, tailbacks and queuing traffic into the High Street slip road. Traffic levels have already increased from the 230 home development in Harbury Park and will further increase when the planned 200 home extension is built there. At least that development benefits from a large roundabout which provides appropriate and safe access to the site. The Radlett plan has already identified Starvacres as a site for housing, which is in a more sustainable location and is served by a way of a wider main road, unlike Shenley Hill, which is in an unsuitable location on a dangerous, hazardous road with a 90-degree blind bend. Halsmere Borough Council was right to reject the application, given the residents' well-founded concerns. Whilst housing is important, it must be balanced with greenbelt protection and focused on the appropriate planned sites rather than a speculative development on unsuitable land. For these reasons, please uphold the Council's decision and refuse this application. Thank you.
Thank you.
Richard Kirk.
Thank you. Good afternoon.
Thank you, Inspector, for letting me speak at this inquiry. My name is Richard Kirk, and I live at 98 Shenley Hill, next to the site, for 42 years. I've enjoyed the views, peace, tranquility, clean air, wildlife, and well-being it provides and will be affected by the proposal. In particular, the access road and the green space immediately to the left of my house. My views will change from open countryside to that of a dense development, and the applicant has not contacted me to discuss my concerns. The site has always been cultivated, harvested for hay, used for 6 weeks for sheep grazing annually, and was once full of pheasants when the farm ran shoots. There is a persistent haze on the site not seen anywhere else, which could indicate drainage issues. Shenley Hill, or its extension Radlett Lane, is not a quiet country lane. It is an extremely busy road with many dangerous bends. The flow of traffic makes it difficult for me to enter or exit my driveway, and would definitely lead to congestion within the site itself. The proposal to add hundreds of vehicle movements next to my house, creating constant noise and pollution, will impact my health. I work in my garden all year and will be impacted by the noise from the green space and play area. My home will be exposed to public view, and I have serious concerns for my safety, privacy, and the enjoyment of my amenity space. 15 years ago, the landowner applied for an exit road on Radlett Lane. For safety purposes, the hedges were set back 9 metres from the highway to improve visibility. The splays were widened and the road was increased to over 7 metres. Highways has not applied a similar robot assessment to this proposal, and this access is a serious safety hazard near a blind bend. making the proposed location too dangerous. 20 years ago, a serious accident occurred in this stretch of road when a car left the highway and ended up in the middle of the site. The crash barrier was installed after that and became heavily dented from repeated vehicle impacts. Last November, the landowner removed the barrier at the front of the site, which is concerning because a crash barrier is definitely needed here. The woodland opposite is not an ancient or protected woodland, but provides valuable natural and visible amenity. It has been felled over the last 2 years and not replanted. Large areas is bare, which has increased water runoff onto the site. I hope the local flood authorities assess this. Finally, the landowner submitted other sites on Shenley Hill for the local plan, and last year they put the Woodhall estate up for sale. If this appeal is improved, I have no doubt the remaining woodland would be cleared for further development. I completely disagree with the case officer's conclusion that the woodland is a permanent barrier. For these reasons, I request that this appeal be refused.
Thank you.
Hi, good morning.
Good afternoon.
Well, good afternoon. Well, so it is. My name is Ian Ellis. I'm a resident of Craighwell Avenue in Radlett.
Thank you.
Thank you for letting me speak at this inquiry on behalf of the residents of Craighwell Avenue. The transport assessment says Craighwell Avenue is a quiet residential street, which is completely inaccurate. It is a congested, heavily used rat run to avoid Radlett High Street. Photo evidence submitted shows anticipated vehicles from the development would overwhelm Craighwell Avenue, Newbury's and Williams Way. No traffic flow diagrams or surveys have been conducted for these roads, and the travel plan, transport assessment and traffic survey have entirely overlooked the wider impacts. These streets are therefore at significant risk. Newbury's school is adjacent to the proposed site. Photos submitted show the congestion on Newbury's and Craighwell Avenue at school drop-off and pick-up times, highlighting safety issues for young children, prams and parents. The photos also show the accident hotspot at the Craighwell Avenue, Theobald Street junction. There are photos that show this hotspot and a very recent accident in July, which I don't suppose is on the record of the council. This was a near fatal collision. The hundreds of additional daily vehicle movements generated by the development would exacerbate the risk of accidents and create further chaos on these streets. No transport impact assessment has been undertaken on Craighwell Avenue, so I conducted my own at 3 p.m. on 23rd of June last year, which I have included in the documentation. In 30 minutes, 95 cars travelled the length of Craighwell Avenue. 7 parked on Craighwell Avenue, but 88 vehicles, that's 92.7%, used it solely as a cut-through. Craighwell cannot accommodate the proposed development traffic, and there is no viable alternative route, placing further pressure on local roads. School coaches cannot turn within Radlett High Street, so instead use a circular route via Theobald Street, Craighwell Avenue, Williams Way and Shenley Hill twice daily. Parked vehicles on Craighwell frequently cause delays. Also, workmen routinely park on Craighwell for roadworks and maintenance, making it extremely difficult for large lorries to navigate safely. Construction traffic currently uses Craighwell Avenue to avoid the 7.5-tonne restriction on Shenley Hill, and was exceptionally visible during the redevelopment of the golf club. The scale of this development would result in years of disruption, noise, pollution, and serious safety risks, particularly to children at the Craighwell Avenue, Newbury's junction, and along the surrounding roads. we cannot imagine how badly our lives will be impacted. The cumulative impacts of this development pose an unacceptable level of risk to road safety. It conflicts with paragraph 155 and 115 of the NPPF. The site is clearly not in a sustainable location, and the anticipated traffic impact on the local highway network in terms of capacity, congestion and safety cannot be mitigated cost effectively to an acceptable level through a vision-led approach. For these reasons, the residents of Craigwell Avenue respectfully request that the Inspector reject this appeal to protect our local roads and ensure the safety of school children and other road users. Thank you very much.
Thank you. Good afternoon.
Good afternoon. Good afternoon, Inspector. My name is Alison Rubinson and I've lived in Radlett for 37 years. I've got a few photos for you, but I'll carry on. This application has many promises, conditions and future mitigations, but only guarantees various contributions to secure its approval. The environmental, highways and safety impacts still remain unresolved. Since the previous inquiry, the Levelling Up and Regeneration Act 2023 was amended to add chalk streams into the definition of environmental protection and natural environment. Radlett supports this extremely rare habitat. There are 200 worldwide, 150 in England and 50 are in our region. The proposed site is in the catchment area for the rivers Ver, Colne and Kitswell Brook. Despite Affinity Water's concerns and the fact that chalk was found in the ground investigation report, there are no assurances as to the protection of the chalk or principal aquifer which supplies the water in our area. During the construction period alone, the groundwater flow could be disrupted, which would cause environmental harm and is a reason for refusal in itself. Traffic is the biggest issue. It is acknowledged that this development will generate excessive traffic. The framework travel plan submitted confirms this, but residents cannot be forced to comply with the plan, resulting in traffic dramatically exceeding local highway and the road network capacity. These issues are compounded by the complete absence of a cumulative impact assessment on traffic and roads in the area. The proposed central reservation raises serious safety concerns. Buses already cross the centre road line on this hazardous stretch of road, and a reservation would restrict movements and increase risk of collision. A Stage 2 road safety audit is required for a central reservation, but this has not been done. Without it, this proposal cannot be relied on, and there is no fallback option. The applicant and highways have relied on the TRICS report to enable 200 to 400 vehicles to safely exit this site at peak times or in an emergency. However, the sites chosen for the assessment all have fundamentally different highway characteristics. None are on a busy, narrow, windy, hazardous country lane such as Shenley Hill. Last year, I took photo and video evidence of traffic flow outside the site, which shows how difficult it would be to exit, inevitably causing gridlock within the development. Here are the photos of gridlock close to Faggots Close, and I also have a video here for you to see, but I'm happy to submit that to you. Finally, the heavily dented crash barrier outside the site was necessary as a protection at this dangerous 90-degree blind bend. In November last year, I also recorded the barrier being removed by the landowner. It is the only crash barrier that's been removed on Shenley Hill. The one at Oriel Cottage and at the top of Shenley Hill remain in place for safety. Its removal prior to this appeal is unexplained. Only a tyre remains, which appears to be from a previous accident. Photo evidence has been submitted and the video of the crash barrier is here if you wish to view it. For all these insurmountable reasons, I request you reject this appeal.
Thank you. Okay. Anybody else? Okay. Thank you for those contributions. So that's now 12:15. For us now, we would normally have a break. However, I'm talking about pressing on to go off and do a formal site visit, if that is okay with everyone. So what I would look to do is to get back here for about 2 o'clock. So I'd like to try and make pace if I can. Would there be someone from the appellants able to facilitate access to the site?
Yes, certainly.
And would any local residents want to come along to that site visit? In the past, yes, 1, 2. Are you happy, are the appellants happy for local residents to come onto the site?
Yeah, yes, in suitable numbers, sir, obviously.
Yep. 2 are interested so far, if that's okay.
That's
that
fine.
can be most helpful. And will someone from the council and the parish council wish to attend that site visit as well? I could have someone.
I think that's the idea.
I'll need, yes, at least sort of one person from each party, ideally. Okay, fine. Yes.
Can I just, is there a possibility we could also do a site visit just generally around Rabbit and the school one time? And I'm very happy for you to come on my school one with me today.
Okay. So I will try to facilitate that. That's something I've done in the past. It'll just have to be whether or not I can do it within the inquiry or I have to do it outside of the inquiry. If you can just settle down and pause until I've made arrangements for the site visit, rather than disturbing otherwise, there are quite a few people. I will let you go and have your lunch shortly. So if I make arrangements to go and see the site visit with the 2 local residents who wanted to attend as well, if we can meet, perhaps giving ourselves until 1:45.
I was going to say, sorry, I beg your pardon to interrupt. We just need to get back and supply ourselves, Miss Brockhurst in particular, with the right footwear, etc., because she wasn't quite ready for the site visit during the course of the day. So maybe say 1. Would that be okay? That'll give us a chance to get back to the hotel.
Sorry, what time do you say?
1 o'clock.
1
rather than
o'clock.
1:45 to start the site visit. That would be great.
That's fine.
Can I just ask at what point, where are you going to meet?
That's just what I'm going to now. So I would just suggest meeting junction of Shenley Road and Faggots Close. There's a reasonable point to meet up there about 1 o'clock, if that's okay with everyone. There is one slightly further down, if that's preferable.
The slip is just before.
Yep, just on Shenley Road itself there. That residential. Is everyone happy with knowing where that is? Just that residential strip there. Yep, thank you. Nodding. I think that's at 1 o'clock.
Yes, thanks, sir.
Okay, thank you. We'll adjourn then for the site visit. As I've said, I've already got a sort of a draft itinerary which I'll try to do. I won't be taking any notes on site, so there's no opportunity for any discussion. I will just have people want to point out individual features to me, but just because I'm not going to be able to take notes outside, there will be no discussion there. And otherwise, we'll meet in that residential lay-by off Shenley Road at 1 o'clock and then return here for 2 o'clock. Thank you.
Do you know Shenley Hill's birthday? It was closed this morning. Kids couldn't get to school because they closed it because of the
Do you know which part of Shenley Hill? Open. Okay. We'll plough on then, and if it goes astronomically wrong, I have other days to do it.
In case that is the case, we said that we should
So it's time for us to resume the inquiry. I was able to conduct the site visit, see everything I needed to see. I think everyone was happy with that, so thank you for the opportunity to do that. And I understand we're receiving some landscape evidence from the council.
Yes, sir.
Mr. Cosgrove, as you ready?
Thanks. Yes, I took the liberty of asking Ms Backer to put herself in the correct place for witnesses. So would you like us to tell you the documents we're going to go to, or would you like us just to do it as we go along? I mean, roughly, I think if it helps. Obviously, Ms Backer's proof and her appendices, which are core documents 6.11 and 6.12. The landscape statement of common ground, which is 6.5. Ms Brockhurst's evidence, which I think is 6.8, and her rebuttal, I think, is 6.15. We might quickly look at the officer report at 2.3. We might quickly look at the LVIA, which is CD 1.26, I think part 1 as it's numbered in the core documents. And then the previous inspector's decision at core document 5.1, and that's probably it, but if there are other ones, I'll let you know, but that's the body of it. Ms Backer, do you have access to, having provided that list, do you have access to those, I hope? Yeah, good. Thank you. Right, can I introduce you to those at the inquiry from your main proof of evidence, please? Section 1. You're Jacqueline Backer. You're an Associate Director of the Landscape Architecture at Lampro Services Limited, where you've been employed since January of 2024. Is that right?
That's correct.
Now, you just as you go along, you'll probably have to speak towards that microphone. I think you've just turned it off. Good. And if people
Is it okay to keep it on?
I would keep it on, definitely.
Okay.
If it goes really badly, I'll say turn it off. Okay, we'll keep it on. And if people can't hear you, I'm sure they'll wave at the background, but I think you can be heard at the moment. Right. Good. And going back to section 1 of your proof, then you've got a master's degree in landscape architecture from Newcastle-on-Tyne. You're a chartered member of the Landscape Institute. You've set out more details of your practice and your experience in section 1, which I won't read out now. Inspectors read it. And we're taking your proof as read. There are members of the public here. You've produced a summary of your evidence beginning at section 10 on page 51 of your proof. And so what we're going to do is just dip into that summary and read little bits of it out for the benefit of the public. But apart from that, just address a few discrete topics as we go through in the evidence. That's where we're proposed to do it. Okay, Ms Backer, does that make sense to you?
It does, yes.
Good. Now, in terms of the issues that you cover in your evidence as opposed to others' evidence, what are they? What's the scope of what matters you're covering at this inquiry?
Sorry, I didn't quite get the question.
So what's the scope of the evidence you're covering? We know you're covering landscape and
I'm
character
covering
issues.
issues 1 in part and issue 2
That are identified by the inspector. Yes.
of the CNC.
Yeah, good. All right, and in terms of planning policy and how it's applied and weighed and weighing matters in the balance, is that for Mr Stroud rather than you?
It does, yes.
Yeah, all right, good, thank you. We'll just start off, I think, by taking up one document for context, and that's the previous decision at core document 5.1 from Inspector Fagan, which you mentioned at various stages in your evidence and has been mentioned by other people in their evidence. Generally, we'll look at the detail in more detail, but generally, insofar as that inspector arrives at conclusions on landscape, character and visual issues, and indeed forms views on the impact on the openness of the greenbelt of the scheme before him then, do you broadly agree with that inspector's view, or do you take a different view?
I do broadly agree with his view, yes.
Now, just at one point, and the inspector has in core document 5.1, he will have seen at paras 36 through to about paragraph 40, the inspector was making some comments on the landscape evidence, and particularly the appellant's landscape and visual impact assessment then before him, which I think, as a matter of record, was produced by the same company or firm that produced the landscape and visual assessment for this inquiry, CSA.
Yes, that's correct.
And you will see that the inspector makes some comments about it, particularly in relation to its methodology concerning susceptibility, as the inspector will have seen there. Now, you've made in your evidence some criticisms of the LVA before this inspector. Very broadly, I don't want to go into detail now, but are they broadly on similar or related kinds of issues?
It is mainly on the assessment of susceptibility.
Okay, good. All right, we'll come back to that appeal decision. I want to just start off with first of all, just go to your summary, if I may, and I want to just deal with issues of site context for the inspector, fresh from the site visit as he is. So can I ask you to read from your summary proof, just read 10.1.1 through to 10.1.3 for the members of the public that are listening.
Following a review of the baseline situation of the appeal site, the application documents and the appellant's LVIA prepared by CSA, I have found the appeal site, located on the verdant southeastern edge of Radlett, forms the last remaining open pastoral field in this location. Its character within the High Cannons Valley and Ridges Landscape Character Area, as defined in the Hertfordshire Landscape Character Assessment, that's CD 4.6, is characteristic of the area's defining features, which are characterised by, quote, an undulating series of close ridges and valleys. The ridges have a well-treed character due to the combination of woodland blocks, scattered trees and tall hedges. Individual houses, farms and small settlements occupy the narrow fringes of the plateau, overlooking the surrounding slopes of both arable and pastoral landscapes, which often have a contained character. I have found that the site was a former parkland strongly associated with the Newberry's estate, a relatively low-density residential development built in the 1950s and 60s, adjacent to the western boundary of the appeal site. In respect of the Hertfordshire Nature Recovery Strategy, the appeal site is also identified for nature recovery in respect of both woodland and grassland, demonstrating the appeal site's landscape and biodiversity value. The area around the Newberry's estate is also recognised within the adopted Radlett Neighbourhood Plan for, quote, its relationship to the landscape and the overall impression of a verdant neighbourhood. Indeed, the settlement edge to the estate is rural, with the appeal site forming the last remaining area of open pastoral land before the landscape becomes characteristically more enclosed by woodland.
Right, thank you. Just pause there. Now, the inspector's just been on site, so will have no doubt be forming his own impression, but of course he wasn't allowed to hear comments and evidence of site. So can we just I just want to talk about issues of visibility, but also character. So can we start off looking at your appendices, please? I think it's your Appendix B. Sorry, your Appendix A, forgive me, where you've got some photographs, haven't you? If you could turn up your appendix,
I did.
Appendix A.
Pardon?
Yeah, you have that?
I do have that.
So do you have that? Appendix A, within CD, within Miss Backer's proof. 6.12, thank you. 6.12 in the core documents. And there's a number of winter photographic views there. First of all, what was the purpose of you taking these photographs in that appendix?
To demonstrate the visibility of the site in winter when trees are not in leaf, mainly due to the reason that the CSA LVIA presented summer views, which provides a greater sense of enclosure.
Yeah. And particularly when we look at them, and if you want to highlight any, please do, but what do you invite the inspector to take from those views in terms of visibility onto the site and or perhaps character of the site in landscape terms?
So viewpoints 1, 2 and 3 represent progressive views on the approach to Radlett from Shenley Hill, and you can see progressively more of the open character of the site on the approach to Radlett. There is woodland associated with the surroundings of the site, and the main point is that you can see very, very little of the settlement edge of Radlett in terms of built form.
Yeah.
And that is because of the verdant nature of that boundary and the large plots in that area.
Yeah. Okay. Now, just within the site, not publicly available views, but relevant perhaps to character. Again, the inspector, as I understand, I'm told, marched into the middle of the site, so he's just been there. But can we look at the, for this exercise, the LVIA CD 1.26 and Appendix C of that document, where we should find a number of photographs. And within that document, it's on about PD 30 something, 33, 34. It's a number of documents, but I'm just interested for present purposes in looking at photographs 7, 8, 9 and 10. So if we look at photograph 7 first of all, if you have that sort of PDF 39, if people are working from electronic copies. So photograph 7, view from within the site looking southwest across the site. Some of you, the inspector will have, I suspect, just seen a similar view in the winter. What does that tell you, what does that view indicate to you in terms of character and relationship with the existing built-up area of Radlett?
We have an open pastoral field with woodland to its eastern edge, woodland to its southern edge, and we can just about make out the settlement edge of the Newberry's estate. But majority of it is treed.
And that's so photograph 8's view looking northwest across the site. Similar points there.
Yep.
And then photograph 9, we've got the view from the eastern boundary looking west across the site to the housing on Newberry's Avenue. And the photograph 10 view from the southern boundary looking north across the site. So you've got the sort of 4 directional views. And you've spoken in your main proof, in your section 2 in detail, in your summary, about the verdant rural character. Is that illustrated by these photographs in your view?
Definitely, yes.
Good. Okay, now, you've given quite a lot of detail about character assessments in your evidence, which I'm not going to go over now, because I'm taken as read and can be asked about that if need be. Woodland, the site has some woodland within it, and it's also has woodland just adjacent to it, which the inspector will have seen. In terms of landscape character, how do you assess that woodland as playing a part in the appeal site context?
It's part of the character of the wider landscape, and it frames the site. When you're within the site, you're not aware that it contains, we still have a very open character of grassland, and the adjacent woodland is characteristic of that wider landscape and provides that woodland character on the approach to Radlett.
Okay. And if I were to invite you to, taking all this baseline context into account, both issues of character and to some extent visual, having read Ms. Brockhurst's evidence on behalf of the appellant, how would you sort of concisely summarise perhaps the key differences between you and her and how you assess this site in terms of character and, in a sense, value? If you were summarising it for the inspector's pen, which I'm asking you to do.
It's in relation to that settlement edge. The appellant's landscape witness sees this as an urban edge. I don't. I think that's where we differ. And I think that view is also shared by Inspector Fagan in the previous appeal.
Let's just pick up that point to give the inspector a reference. Core document 5.1. Do you have a particular paragraph in mind when you say that in the previous inspector's decision?
I'm just trying to find it, sorry.
Luckily I do. It's paragraph 41, just to move things along.
I've got it, yeah.
41 and perhaps 42. Are those the ones you had in mind?
He states that...
You just read out for those listening, but perhaps 41 of the inspector's decision. It's quite short.
The appellant's landscape evidence in this regard, on the contrary, seems to be overly coloured by the site's relative containment by the woodland blocks and its influence by proximity to the housing on its western boundary. However, neither affects the site's intrinsic character as an open pastoral agricultural field, the character of which would be substantially adversely affected by the development. The majority of the site's boundary is with woodland and not with the urban built-up boundary, which only accounts for about a third of it.
Okay, thank you. And just on the character point, in terms of, I think in your proof you've set out some references to various character assessments and identified this, one of the characteristics as being woodland blocks and open fields. So how relevant is this site and the associated woodland to the character of the countryside around Radlett?
The woodland's part of the character of the surrounding woodland, with the pastoral field and the relationship between the two being very important in terms of its openness on the settlement edge.
Good. All right, I want to move on to the next topic, if we may, which is landscape character issues. And I'm going to try and avoid going into the finer points of Glivia assessments, but just deal with headline points in chief. Can I deal with the issue of sensitivity of the site and various receptors that are relevant to landscape character? And perhaps we can just start by going into your main proof, please, and looking on page 30, table number, forgive me, page 27, table 1 in your proof. Beginning on page, hard copy 27, going through for the next 2 to 3 pages to page 30. Do you have that? And so do you have that? Thank you. Now, this is a table that's headed Assessment of Landscape Sensitivity, and it's right, I think, on this table, you're giving your view, are you, of value and susceptibility as inputs into sensitivity, and you're also comparing your views with that of the appellant, which at that stage was the LVIA, because, of course, you hadn't seen Ms Brockhurst's evidence at that stage.
That's
okay?
Correct, yeah.
Again, the inspector will, I'm sure, have looked at that, and you break it down into various landscape receptors. Yes, and in particular we've got the grassland, topography, woodlands and hedgerows, and there's a site character, overall character of the site section on page 29, and then you go beyond the site to the high canon, valleys and ridges, LCA. Yeah? Yeah. Okay, now again the inspector will have seen that. What broadly, how would you characterise the differences between you and the LVIA in terms of sensitivity? I'm not going to go into the particulars of value and susceptibility, everyone will be pleased to hear. Just the headlines as to sensitivity.
The fact that the appeal site is the last remaining pastoral field on this edge of Radlett before the landscape becomes enclosed by woodland and the rising topography to the east. Even when the grassland has limited visibility, the appeal site retains a perception of openness and an absence of development. The intrinsic value of the site is derived by its open pastoral character.
Yes. So probably my fault. What I'm interested at the moment is how would you characterise the differences, the overall findings as to sensitivity between you and the LVIA?
In the way that we see the settlement edge, whether it's urban or rural.
All right. When we look at the findings at the end, we've got your findings of high, medium, and the LVI assessments.
That's correct, yeah.
Okay. Now, in terms of Miss Brockhurst, forgive me, assessments of sensitivity in her proof, what do you say about that, and where do you understand she lies in terms of your findings on sensitivity?
At the opposite end of the scale.
Right.
She sees that there's a very strong urban relationship between the site and the settlement edge, and its containment by the woodland, which devalue the site's sensitivity and value and sensitivity.
Okay. And as you understand it, does she take a slightly different view on sensitivity from that in the LVIA as well?
She does, yes, because the LVIA considers the overall site as medium, and she assesses it as being of low sensitivity.
All right. Now, in terms, just for the inspector's note, again, we don't need to go to it in chief, but in your main proof, at section 5 on page 24, And then also at section 6.1 on page 25, following on for the next page or two, you've set out various criticisms of the LVIA approach in some detail. Okay, that's where they're set out, is that right?
That's correct, yeah.
Some of which cover the LVIA's approach to sensitivity.
Yeah.
So far as the appellant's evidence have you seen now, there's reliance on two documents relating to sensitivity assessments. And just to address these, can we just go to your main proof, page 19, please? And if we look on page 19, you set out at section 4.1.1, little 1, little 2, there's the landscape sensitivity to residential employment development in Hertsmere, that's core document 4.7. And then you refer to the outline landscape appraisal, OLA. I think there's an error there, isn't it?
There is, yes. I refer to it as the Stage 2 Greenbelt assessment, but it was the Stage 2 sensitivity assessment, which is CD 4.8.
So it's moving inspector. So it's not 4.5, it's 4.8. And it's 4.7 and 4.8, the two documents relating to sensitivity. Is that right?
That's correct, yeah.
Just dealing with each of them in turn, again, quickly, because you've set out your position in detail on the first one at 4.2, just below, and you set out some particular points about that sensitivity assessment, that's core document 4.7. For the reasons you've said, and having seen the appellant's evidence now, do you think that document is going to provide this inspector with any particular assistance on how to assess the sensitivity of the appeal site in this case?
No, I don't.
Good. And is there anything you need to add to what you've said in your proof to explain why that's the case or not?
Because this is a sensitivity assessment for a generic type of development rather than the proposal that we have before us today.
Yeah. And then at 4.3 you deal with the OLA, if I can call it that. Again, one needs to amend your 431 because it's not part 2 of the Arab Greenbelt assessment. But in relation to that document, you tell us at 4.3.4, for the reasons you say, because it doesn't assess, that document you say there, doesn't assess the intrinsic value of the site and its susceptibility to a particular quantum. You said, I consider it does not help inform any judgments about the development being proposed, which is the subject of this appeal. Does that remain your view, having read the appellant's evidence for this inquiry?
I think that's very a different view. I don't see this as relevant to the specific development in front of us, rather than, and to the questions relating to Greenbelt, for which this sensitivity assessment was prepared for. And as we are asking a different set of questions.
Okay. Right, good. That sensitivity. I want to move on to magnitude of change and the sort of level of effects, the second part of the Glivia exercise. Can we go, for that purpose, to your proof of evidence and look at your table 2 on page 32, please? And again, is this where you set out your assessment level 1, level of effect at year 1 and 15, and then set out the LVIA's findings as well, as you understood them?
That's correct, yes.
And again, just the headlines, the inspector will have seen, you find a number of, so far as your evidence, number of findings at year 1 and 15. The land use, you find substantial adverse at year 1 and 15. And then just going through to the overall character of the site, sensitivity on page 34, you find level of effect year 1, substantial / moderate adverse effect, and year 15, moderate adverse. Often members of the public listening to that will think, well, what does that mean? What does that mean? What happens between year 1 and year 15? When does it become moderate? How does that work from a landscape assessment point of view?
It's in relation to mitigation planting, which takes time to mature and to become an effective screen. We normally assess this at year 15, having a complete effect on screening proposed development. But between 1 and 10, that screening has limited value, so the effects only reduce in the very long term.
Right. And I mean, because, as you've explained elsewhere in your proof, character does have some visual elements, but it's not solely about visibility, landscape character. I mean, if one was to ask, if the inspector would say to you, what's happening at year 10, for example, in your assessment of landscape effects on the overall character of the appeal site, what would you be saying?
There'll be young trees that we will see that will provide...
No, sorry, forgive me. In terms of how you would describe it, substantial, moderate, how would you describe it?
Okay, apologies. Okay, so at year 1, there's going to be very little mitigation because it's recently planted. So the effects are what they are, and they will only reduce over time.
Yeah, so year 10, what would you say, or don't you know?
I would say it's still substantial.
Right. Okay, thank you. Now, I think in terms of the differences, we look at Ms Brockhurst's rebuttal proof of evidence, please, which is core document 615, I think I said. And within that, there is a table that is produced on page 4 of that rebuttal, table R1.1, headed comparison of significant effects. Now, we've got a table there with appellant's effects at year 15, council's effects at year 15, and the Rule 6 effects. And you can see that just looking at the overall site character, which we were just looking at a moment ago, appellant's effects at year 15 moderate, council's effects at year 15, it said moderate for you. Are there any points you want to make about that in terms of levels of effects?
Because that's at year 15, so it takes into consideration the effect of mitigation planting.
Yeah.
It's not relevant to the year 1 effects, where I assess the overall character of the site as significant.
Or year 10, as you just told us a moment ago. And then we've got the Rule 6 judgment as well. And we see, apart from that, is it a fair summary of the differences between you and the others, just as a matter of record?
Yeah, apart from I feel it's a little bit distorted because it doesn't show the whole picture. As noted, the Rule 6 judgments are only at year 1, so it's not comparative.
Now, these are all noting in this table findings of effects characterised as adverse or beneficial and characterised as substantial or negligible or moderate, using the sort of scales which the inspector will be familiar with. So those are effects, we know them from Glivia. Slightly different is it, I ask you, when an inspector sees sometimes landscape experts say, I'm now going to tell you what I think the significance of the effects are, as opposed to whether something's substantial or adverse. Help us when an expert like Ms Brockhurst or you talks about whether something is significant in terms of effects. What does that mean?
To me, it relates to EIA, and Glivia does that extra step from converting an assessment of an effect to whether that effect is significant or non-significant.
Right. So, because just to take the overall site character, I think we can go to Ms Brockhurst's proof, says at some stage she doesn't disagree with Inspector Fagan's broad findings, or indeed, we see on the table she's finding, for example, moderate adverse effects on the overall character of the site at year 15. But she also says, if you take up her proof, she also says, for example, at paragraph in the inspector's note, paragraph 517 of her proof on page 38, when she's concluding on a section which is looking at the extent of which any adverse effects to landscape character are significant. She says at 517, in concluding on this issue, it's my professional opinion that the landscape effects are not significant. There's nothing in terms of the physical and visual environment that has changed since 2023 when landscape matters do not form part of a reason for refusal. Mr Allen addresses the weight and the planning balance. So, again, Mr Stroud's going to address weight and balance, but just this idea that a co-expert is agreeing that there are serious, as it were, levels of adverse effects, but then concluding there are no significant effects. What's your view on that, an approach?
It doesn't match. I feel that it doesn't take account of the permanent change in land use of the site. And she seems to accept development on the site as a reason for not considering there to be significant or substantial effects.
Now, you haven't used the terminology significant. I mean, either did the inspector or either did others in addressing this. But if you were asked to take your conclusions of substantial or moderate adverse long-term effects on various receptors, how would you characterise that in terms of significance?
I would consider the substantial and moderate substantial effects as significant.
Yeah. All right, thank you. I'm going to move on from landscape character. In terms of visual effects, I think we can take this perhaps a little bit more quickly. If we take up the landscape statement of common ground as a starting point on that, and we have within that a table, as I recall, not being able to put my finger on it now, that deals with visual effects, don't we? And in matters of agreement between you. Yep.
Yep, I have it.
And what? So, where does the difference lie in terms of visual effects between you and Ms. Brockhurst?
We agree on the fact that there is limited visibility from the wider landscape, and we disagree on the level of effects on near-distance views near to the site, particularly from Shenley Road.
Yeah, and I think this is where the inspector, I think, will have just been, and then you, in your evidence, you talk about going down onto footpath. I think you call it 55. It should be 5, shouldn't it? Footpath
It's
5.
correct, yeah.
Is that where you're talking about? Is that the area?
Yeah, Shenley Road and the footpath, which is also in close proximity.
Yeah. Now, again, the inspector will obviously form his own views on that, and he's seen your evidence. But I just want to pick up on one point, looking at Ms. Brockhurst's rebuttal evidence in relation to your evidence. So it's section 2 of Ms. Brockhurst's evidence where she addresses your proof. And she makes some points about hedgerow loss at 2.9 following hedgerow loss on Shenley Hill. And she refers to your evidence where you assert that the hedgerow is completely removed on this is on the Shenley Road boundary, and would there be open views to new built form as compared to the existing filtered views. And she says this statement is incorrect and gives the inspector some references and refers to the arboricultural report at CD 1.12 and indeed the biodiversity impact calculation. Now, and she says the appellant does not and has not sought to remove the hedgerow on Shenley Road. And then she also refers, to demonstrate further her point, to the Rule 6 landscape witness, Ms. Brown, and her AVRs to show that, because the hedges remain on the AVRs. What's your response to that? Have you got it wrong?
I don't believe I have.
Right. And what's the best place to demonstrate this to the inspector?
The access plan.
Yes, core document
one of the core
1.2.
documents, yeah.
So if you could, however you want to find it, electronic core document 1.2. Yes, that's the one. That's one of the ones that's obviously not part of the outline. That's what I think in condition 3. That's tied in as one of the 2 or 3 plans that have to be built in that way. So when you look at this plan, however you're looking at it electronically, what do you say it shows us? And I think you can see faintly underneath the access the former tree and hedgerows, can't you? Well, what do you say it shows us?
It shows the tree removal in relation to the access. It also shows the widening of the road by at least 2 metres to provide a central crossing. And it also shows that that will take approximately 2/3 of the hedgerow along Shenley Road out.
Yeah. So
I see that the majority of that hedgerow would be removed.
Now, of course, it's right. There's space in the proposals for new hedging and screening to be planted. going forward, but in terms of when that would have a effect on visual or screening or filtering, how long do you assess that to take, and it's likely to take before there's any material
At
impact?
least 10 years.
And just to pick up on the point about the, because perhaps we'll just give the inspector a reference, because it said, well, even the Rule 6 parties got this right, I think Ms. Brockhurst says, on the, what do you understand the AVRs that the inspector will have seen from the rules, Ms. Brown, which show the built structures, but they show the road and the hedges remaining as they are? What do you say about that?
The drawings are caveated, saying that they do not show the roadworks in those visualisations.
Yes, and I think just for the inspector's notes, so he's got a reference on that. It's Ms. Brown, we perhaps don't need to go to it now, but I think it's Ms. Brown's proof of evidence at 6.33 of her evidence on PDF page 50, which says the AVRs indicate the likely effects resulting from the proposed height and massing of the houses on the developable areas as shown on the parameters plan, but does not model the vegetation removals, planting, or the highway proposals. And the highways extend the road about 2 metres further south into the hedgerow.
That's correct, yes.
All right, okay. Thank you. Good. I mean, there is, I should just say, is there anything you want to say about the nature recovery document? I call that very loosely, calling it the wrong name, because that's mentioned in the rebuttal as well in relation to your evidence.
I thought it was interesting that the councillor mentioned this morning that that plan has now been adopted. So I would say it carrying weight in the decision. It was a document that I referred to in my proof of evidence to demonstrate the value of this site and its pastoral character and how it could contribute to nature recovery strategies. That led me to consider how the development has been landscape-led or not. Certainly it would be a document that I would go to if I was master planning the scheme, to allow sufficient buffers and room to provide space for that nature recovery strategy.
Okay, thank you. Right, I want to move on to the next topic, which is Greenbelt, and I want to first of all deal with openness. And this will obviously be a particularly relevant consideration if the inspector finds the site is Greenbelt as opposed to Greybelt. That's a matter for others in the balance. So I want to deal with the effect on openness, and I'm tentatively going to ask you to go to CD 2.3. Have you managed to download that? It's quite a large document, and the internet is not that great here. Have you got that downloaded?
That was the
That's
committee
the officer report.
Yes, I
Do you
have
have
managed
that?
to get that.
So do you have that as well? Great, thank you. And obviously it's a report which comes to a different conclusion and recommends approval for various reasons, but for present purpose, I just want to look what it does say about openness. So can we go to PDF page 52, which is in the internal paragraph numbering 7.4.3, and there's a little subheading, openness of the Greenbelt. Okay.
Right, it's being rather slow.
Right. If you can't get it in a minute, we'll do this another way, but to see if you can get there. If you can't, I tell you a lot, in the interest of time, you've got core document 5.1. Yeah? That's the inspector's decision.
Okay.
Yeah? Do you have that? So I do it another way,
do.
because we'll take ages downloading things. If you go within the inspector's decision, please, to paragraph 30. Do you have that?
I do, yes.
Page 6. And he's got a little subheading, conclusions on Greenbelt harm. See that?
Yep.
And he says the proposed 8 hectares of built development would have a significant adverse effect on the Greenbelt's openness, which would be a physical manifestation of its inappropriateness. In terms of the Greenbelt purposes, the development would have a moderate adverse effect on purpose A. It sets out purpose A would have a moderate effect on purpose B, and then refers to C. while this significant effect on openness and adverse impact on greenbelt purposes may well be, quote, inevitable, in the appellant's words, as a result of the inappropriate development of up to 195 homes and a new medical centre, such inevitability does not lessen its considerable harm to the greenbelt, to which I must give substantial weight. Now, I'm not asking you about weight, but in terms of the characterisation on the effect on the openness of the site, if this scheme is built out, do you agree with that approach?
I certainly do.
And as you understand it, did the officers in the report we tried to get to take the same view as the inspector? Right.
Yes, they put that in their report.
In fact, I think they quoted from the inspector in the report. Yeah. In your proof, if we just take up your proof, you deal about openness in a number of places, but if you can go in your proof to 9.4.7, please, of your proof. You dealt with the context of openness earlier, and 9.4.7 of your proof. Hidden away amongst your assessment of purpose A, you turn your mind about halfway down that paragraph, you say, in the context of the proposed development, and then you refer to the loss of the soft settlement edge, and you say that the development would render large-scale housing at the new settlement edge contrary to the character and because it would erode the sense of openness provided by the appeal site of the settlement edge. So is that a similar view as to what you understand others have expressed? Okay, all right. We'll leave the assessment of where that goes in terms of weight to others. Greenbelt purposes. So you have done your own assessment as to whether the site makes a strong contribution or any other kind of contribution to purposes A and B. Mr. Stroud's also done his own independent assessment. We'll come to him later. But so far as your position is concerned, can we just first of all, and that's obviously a key issue between us and the appellant, go to your proof at page 46, paragraph 9.4, please. Page 46, 9.4, you've got a subheading, purpose A, to check the unrestricted sprawl. Yep.
Yep.
Now, just to be clear, when one looks at that section, and particularly 9.4.2, you say the first point to make about the assessment of whether a site is grey belt or not, in accordance with the purposes, is that the assessment is fundamentally one of planning judgment. And then you refer to the illustrative features and the planning practice guidance that concern you. Does that remain your view? It's a matter of judgment?
Definitely, yes.
And you identify what you call limitations. It's important you say to recognise its purpose and limitations. At 9.4.3 you identified two. One is that you identify the guidance states on its face it's illustrative, various features, and then secondly you say a few lines down, whilst therefore the guidance is of use, the purpose of the guidance is not to definitively enumerate features which must or must not be present for a particular contribution to be identified. And is that the way you've approached your assessment? Yeah. And you set out some more detail below, which I don't read out now. And then you set out your detailed assessment in relation to purpose A. Can we just, for present purposes, rather than go through all that in detail, because we can take it as read, just go to 9.4.11 and read out the summary there at A, B and C, please.
So following my assessment, I accordingly consider the appeal site performs strongly against green belt purpose A, to check the unrestricted sprawl of large built-up areas, because I consider the appeal site forms part of a valued soft edge to the existing settlement boundary, facilitating transition between the urban and rural in a manner which operates as a critical buffer zone, preventing urban sprawl into the adjacent rural area. B, the appeal site is adjacent to a large built-up area and is free of existing development. Two illustrative features of a strong contribution to purpose A as per the guidance. Development of the appeal site would also result in an incongruous pattern of development, as above, because it would promote development to the south of the appeal site and because it would promote a density of development which is incongruous to the tapering of development as one approaches the edge of Radlett, again contrary to the guidance.
Now, again, there are a number of points of difference here. One of the points I suspect that might be raised with you is the issue of the woodland and whether it could be said that the woodland represents a physical feature in reasonable proximity that could restrict and contain development. That's one of the illustrative features in the strong category that a site is likely to be free or lack physical features that might do that. And you'll see that I think maybe it's not Ms. Brockhurst, Mr. Allen's assessment. He assesses it as having a moderate contribution to purpose A and says, well, these woodlands are physical features that weaken. He puts it the land's contribution to this purpose, which gets you in the moderate rather than strong category. What do you say about this role of the woodlands? Clearly there are woodlands there. Clearly they're going to stop visually the site being seen from some parts, not all parts. But in the context of making an assessment in relation to purpose A, how do you see them as playing?
I see them as part of the wider landscape. They're a characteristic feature of the landscape, and although they are adjacent to the site functions as part of the open land on the settlement edge, and the verdant character of that settlement edge really helps form, and the site itself restricts sprawl.
And you've talked a lot about the character of the woodlands as being, mentioned in various landscape character assessments in this area. I mean, for example, as opposed to perhaps there being large tower blocks there encircling the field, do you think this woodland, looking at the wording in Purpose A, the moderate section, could be characterised as something that weakens the contribution of the site to Purpose A?
No, I wouldn't.
No. All right. And again, there are various appeal decisions which we can go to in due course. I won't trouble you with them in chief to illustrate this. But just before we go to Purpose B, there are two documents which the appellant says on this issue rather assist the inspector to support their case, and those are the ARUP assessments, so I can call them that way, characterise them that way. Can we just turn on this? We'll come back to your part of your proof, but just on the ARUP issue, go to your proof, please, at page 44, 9.2. And you've got a little subheading, ARUP Greenbelt Review, and we know there's a stage 1 assessment 4.4, and then we've got a stage 2 assessment 4.5. And the appellant basically praises NAID. I'm doing them a disservice. They put it much more eloquently and subtly than that. But what I'm interested in is what do you say? Do those studies, in your view, assist the inspector in coming to a view on whether this site contributes strongly to either Purpose A or B?
No, because they're not asking the same questions, the same test as the grey belt test. So these are based on wide areas. Certainly the stage 1 assessment has no help in assessing grey belt purposes. On the second green belt assessment, it does not consider the same questions of grey belt as it set out in the PPG, and therefore I don't think this has any help in providing a commentary on assessing Purpose A and B.
I mean, I think you said this on your brief, does the stage 2 assessment even address Purpose A at all in relation to this site?
Not at all.
Because I think it forms the view that this is a village, not a large built-up area, so it doesn't address Purpose A. I think that's right. You tell me if I'm wrong.
That's correct, yeah.
Hopefully fairly lead you on that. So, and just a moment ago I asked you in relation to Mr. Allen's evidence about he placed one of his arguments weight on the particular wording that we now find in the PPG under the moderate category for Purpose A of whether a particular feature, quote, weakens a land's contribution to a purpose. Do those kind of questions and tests exist before the grey belt tests, which we now have in the NPPF and the NPPG? Those kind of questions, were they around to consider and grapple with?
No.
Did the previous inspector have those kind of tests? Mr. Begland, I should have made this point, Mr. Begland in opening said he felt there's a good argument that the Inspector Fagan, if he were looking at it now in light of the purposes and the guidance we have of how to approach this strong or moderate contribution, might well have found a strong contribution. What's your view on that?
I would think the same, because he agrees with the significance of effects, the value of the land, and the way it functions as an open site in relation to particularly Purpose A.
Yeah. Now, the other document which is relied on I want to get your view on, and in fairness, you haven't addressed this in your proof, but it's raised now in the evidence, and perhaps you should have done, but you haven't, and I want your view on it now. And that's the core document 1.25, which is the CSA assessment. I think it's from July 2024. 1.25. It's called the Greenbelt Review. Let's let the inspector get that up. It's done by CSA, so the same authors of the LVIA Greenbelt Review of Land at Shenley Road, July 2024. Seen that? Any better chance to read and consider that?
I have, yes.
And that forms various views at that stage. Now, to be fair, that was obviously pre the MPPF December 2024, and certainly pre the guidance now we have in the February 2025 updates. But again, I think I can lead just to save time on this. As one sees in the text when you read it, it was considering, it knew about the theoretical concept of grey belt in the draft consultation, which was then in existence. But I think a slightly different test. But what's your view on the conclusion? Because it concludes, I think, very low or slight, weak contribution to A, I think, and B, so weak or negligible contribution to the appeal site. What do you say about that body of work?
I don't have a lot of faith in it. It, again, concentrates on the fact that it's an urban edge and not a soft, verdant, green settlement edge. It doesn't correspond to the findings of the planner himself either, because
Mr. Allen.
Mr. Allen, yes.
No.
Because he assesses it as moderate for both purposes, while this assesses it as weak. They did not have the same illustrative features set out in the MPPF that we have now to consider the more contextual elements of this assessment, and I don't think it really helps the inspector in the decision making today.
Yeah. And it's also said, of course, you'll have heard in the opening from the appellant today, well, on their list of people who disagree with us, they say, well, the council own officers concluded the site did not perform strongly against ALB when recommending the scheme for approval, which is absolutely fair. In the officer report, they did form that planning judgment. Is that your planning judgment, or do you disagree with the officers?
No, I take the view that on purposes A and B, that the site performs strongly against those purposes.
Yeah. I mean, it's not a numbers game, as I will say at these kind of inquiries. We could all bring lots of people along to say things, but as it happens, if we're in a numbers game, are there other independent professionals sitting behind me, I think 3 in number, who also share the view that you do?
Yes, I think the Rule 6 party also share that view.
All right, okay. Fine. And I'll leave Mr. Stroud to deal with the Casey advices in due course. Now, going back to your assessment, we looked at purpose A. Go back to your proof, please, purpose B, which you address at 9.5, page 50 of your evidence. Again, you set out your detailed reasoning there, which differs again from the appellant, but accords with other professionals at this inquiry. Just read your summary at 9.5.6, A and B, please.
Having done my assessment, I accordingly consider that the appeal site contributes strongly to Greenbelt Purpose B. The appeal site is a tract of land, if lost, would result in the shortening of the distance between Radlett and neighbouring towns. There are a number of perceptual dimensions: topography, the appeal site's verdant character, its relationship with the settlement edge, that the appeal site shows, by which it strongly contributes to a sense of separation between neighbouring towns, which would plainly be lost were the proposed development to be allowed.
Thank you. Now, I'm just going to end your evidence, go back to your summary, please, particularly for those members of the public here, rather than the inspector who's had the opportunity to read it, just in case they haven't. Can we pick it up, I think, from 10.16 on page 52? I'm going to ask you to read to the end of your summary evidence, please.
In my opinion, The CSA LVIA has underestimated the sensitivity of the appeal site and how it functions in providing the verdant rural approach to Radlett from the east. It has also underestimated the permanent magnitude of change that local residents and users of footpaths on the edge of the settlement will experience as a result of 195 dwellings. I have evidence that the appeal site and its surrounding landscape is highly sensitive to change and assess the magnitude of change to be substantial. As such, the overall effect on the appeal site and the character of its surroundings landscape would be substantial adverse. The development would result in the permanent loss of the existing open rural landscape on the rural approach to Radlett and would extend the settlement edge east along Shenley Road into open countryside. The evidence I have provided following my appraisal of the appeal site, its surrounding landscape and settlement character supports the Council's one reason for refusal. I have also considered how the site contributes to greenbelt openness and assessed the site's contribution to purpose A and B in terms of the appeal site being considered grey belt. I have assessed the appeal site as strongly contributing to purpose A and B and consequently conclude that the test for grey belt set out in MPPF 155A is not met.
Thank you. Unless there's anything else you want to raise in chief, those are my questions to you. I'm sure there'll be some questions for you. So thank you. I managed to shave half an hour off my time estimates. Get in.
I wouldn't mind a glass of water.
Oh, maybe.
Oh, there we are. Thank you, Mr. Cosgrove. Yeah, may we have 5 minutes? Would you like me to give you the list of documents before we have that break? Some of them I think you've got open already because they were given to you by Mr. Cosgrove. But in addition to Ms. Backer's proof and appendices, I think you had the landscape statement of common ground, which is 6.5. I think you had that one open. And I think you had core document 2.3 and 2.5, which are the report and the minute. In addition, could you have the decision letter, which is 5.1, which you may have open from last time, 2.6, which is Mr. Cannon's opinion, 3.9, which is the PPG guidance on purposes and grey belt, 4.5, which is the Arup Stage 2 report, 1.26, I think we had, did we, the LVIA Part 1, 6.4, which is the main statement of common ground. I'm not sure we had that one open. And then you had the rebuttal open, I think, and then two others. Miss Brown, the Rule 6 witness on landscape, her proof 6.14, that is core document 6.14. And you and others may have this separately, sir, but the MPPF, which is, I think, core document 3.6, if one wants to look at it online. Thank you. and the benefits not considered to outweigh the harm to the greenbelt and landscape harm identified. And it's agreed, and we can look at the landscape statement of common ground, which you were the signatory to, I think, with Ms Brockhurst, that what that shows is that the council has not identified, has it, landscape or visual effects, adverse landscape or visual effects, as freestanding reasons for refusal. That's correct, isn't it?
I wouldn't say so, because landscape harm, in my mind, is landscape and visual effects.
So no, let me just, sorry, we may be at cross purposes. Let me put my question again. The council hasn't identified, has it, as a reason for refusal that permission should be refused on its own terms because of adverse landscape or visual effects?
Not on its own.
Right. Okay, thank you. I thought we were at slight cross purposes. Because at that point, I think, agreed, isn't it, in the landscape statement of common ground, that there isn't a freestanding reason on landscape?
That is correct. That
you were the signatory to. So that, for your note, that's 1.1 and 1.24 of core document 6.5. I won't go there now. It's points agreed again. Okay. All right. And obviously, if you're the inspector or anybody looking at the council's position, one can get a sense, can't one? One should get a sense from the fact there's no landscape freestanding reason as to the relative importance in the council's resolved case by the members of landscape and visual compared to the green belt impact they say there'd be. Correct?
Correct.
Thank you. And again, I don't want to take too much time on this, but can I just ask you to go to core document 2.5? 2.5, please. And I know that you were having a little bit of difficulties, as we all were, I think, at times with downloading things, but you can just open it on the screen.
It's loading.
That's the minutes.
It's loading.
You with me? You don't have to download it, you can just open it.
I am just opening it.
Guest or the public Wi-Fi?
Public.
Okay, that's slightly slower than the guest. We'll have a short pause so we can get you onto the guest one, which I have.
Good idea, sir.
The password. for
Have
that.
you?
Apologies, I could have checked that earlier if you wouldn't mind just handing that down. Or perhaps. Sorry, Mr. Warren, slight pause once you sort that out. Thank you.
Oh, God.
It is not the most, it doesn't roll off the tongue, that password.
Having trouble finding that list. And then it's actually open now. If I can leave that here for a second.
No, if you're happy. But you might need to open up documents. It might just be worthwhile.
I've got most of them open, just not that one.
But it is now open for you. Okay.
So, Ms. Backer, I was in that document, if you wouldn't mind going through to PDF page 4, you'll see that there was it was proposed by Councillor C. Gray. See about halfway down the page, or third to halfway down the page, that the recommendations as set out in the report be agreed. So that was those were the recommendations, you'll remember, to grant planning permission, and there was a vote, and there were 13 votes, and that motion was rejected 7-6. And then Councillor Rosehill proposed refusal on all grounds that the application did not comply with the grey belt designation OVSC. Councillor Lambert seconded. And then there was some advice, wasn't there, given by the Assistant Director of Legal and Democratic Services. Have you seen this one before?
I have,
Okay,
yes.
fine. And then there was a vote, and we can see what the motion was. If you just go to the top of the next page in bold, it says, resolved, the application be refused on all grounds that the application did not comply with the grey belt designation it had been given, and there were not very special circumstances for building on the green belt. So that was what was actually resolved, and there's actually no reference, is there, in the way that the members are recorded as having resolved to landscape and visual impacts at all there.
It would appear so, yes.
Yeah. Okay. Again, it's just a matter of relative importance is what I'm advancing. But I want to turn to the greenbelt points you make, and I'm going to try and stick to kind of judgmental points that you rely on rather than strict policy points, if you like, because I know that Stroud's going to deal with those later on. But just before we do, you're aware, aren't you, that the council's position is that if the site is in fact found to be grey belt, then there would be no basis upon which to refuse permission, correct? You're aware of that?
I am.
Okay. All right. The council, again, I'm just clearing a couple of points out of the way before we look at the judgments that we do disagree on. The council agrees, doesn't it? Are you aware of this, that the golden rules in the NPPF would be met by the scheme?
I am aware of that, yes.
Okay, that's in the, again, so for your note, that's 4.19 of the Statement of Common Ground, 4.19 at core document 6.4. We don't need to go there. All right. We mentioned it a moment ago, but just go, would you please, to core document 2.6. And again, let's fingers crossed this is one of the ones that you had open earlier. Yeah, it's a letter, and it I think encloses the.
I don't have it open, no.
You don't, do you? Right. Would you mind getting that open? It's not a particularly big document, which may help.
Did you say 2.6?
2.6, yeah. It begins. Sorry, I'll wait till you've got it open.
From Joseph Cannon.
Are you with me? Yeah, is it open? Yeah?
Just about.
Thank you, just about, okay. So you'll see that it's, the document is an email, I think, dated the 11th of September from Democratic Services to the Planning Committee, and it's a late, if you like, appendix agenda item for the 18th of September meeting, and it's called Legal Note, yeah? Yeah. The opinion from Mr. Cannon is notable, isn't it, if you look at paragraph 1, because he was the barrister who acted for the council in the last inquiry, wasn't he?
He was, yes.
Yeah. And he, I don't think we need to spend time on this now, when he turns to the grey belt, which begins at paragraph 10, there's a subheading, the grey belt.
Still not opening. Just about. Paragraph 10.
Paragraph 10, it says, there's a little subheading, it says the grey belt, and it begins in the briefest of terms, grey belt's a subset of green belt land. Are you with me? Yeah?
I've got that, yeah.
Got that, okay. Mr. Cannon notes at paragraph 11 that the purpose of the introduction of the concept of grey belt appears to have been to unlock development on parts of the green belt, and he talks about judgments involved in that. He gives us the definition which is in the NPPF of grey belt at paragraph 14, if you just scroll down to that.
Mm-hmm.
And I just want to use this to identify again, so that there's absolutely no doubt about it. Are you there with the? You're there with the definition. Okay. So it's right, isn't it, that the council and the appellant don't have between them anything in relation to purpose D? Is that right?
That's correct.
Or anything to do with footnote 7.
That's correct.
Okay. So doesn't strongly contribute to any of purposes A or B. And again, rather by contrast, I think, to some of the earlier commentary by Minister or Secretary of State, Mr. Reid. Do you remember the third parties were reading out things that he said when he was in his former job and so on? This definition isn't just about car parks and petrol filling stations, is it? It identifies grey belt as land which may contribute modestly or moderately or in a medium way, as long as it doesn't contribute strongly. That's the bar. That's where the bar was set in the final version of the MPPF, wasn't it?
That's correct, yeah.
Okay, thank you. Mr. Cannon deals with a number of points. I won't cover all of it, but if you go down to his paragraph 17, he refers to a point that you covered in your evidence in chief, I think, which was what one should make of the work that was done by Arup. Now, I'll come to that in a second, but he says, doesn't he, let me just remind you about what he said in 16, the judgments about the two purposes, for the purposes of underpinning decisions made in the plan-making sphere, such as whether to allocate greenbelt land for development. And he says, Hertsmere is no different, having commissioned Arup to produce a multi-stage assessment of its greenbelt land with a view to informing its own replacement local plan. He says it's true that all of that work was done prior to the introduction of the concept of grey belt, but nothing turns on that. And the reason he says that is obvious, isn't it, Ms. Backer, that the purposes, what the purposes are, purpose A, purpose B here, they haven't changed at all, have they? They didn't change at all in December 2024.
No, they haven't changed, but the way you assess them has.
Right, I think we've got some more guidance about grey belt, but the question about what purpose A is, and what is purpose A, and judgments about whether a site or land contributes strongly to it, nothing's changed about that in December 2024, has it?
Yes, because it sets out a number of illustrative features to help define whether a site contributes strongly or not, or moderately or low to those purposes.
So anyway, your view is it that the PPG didn't just provide further guidance about how to identify the grey belt, but somehow introduced a wholly new way of telling whether a site contributed strongly to purpose A, for instance. Is that what you're saying?
Yes, it's a new test.
I see. So quite different then from before. It's a new test, but of course the purpose, as you say, is the same. Purpose A and purpose B haven't changed in what they are in the MPPF. And I don't think you say, do you, that the judgments that, or do you say this, that the judgments that Arup formed are irrelevant now?
I do, because the test is different.
Okay, so your position is that the Arup judgments are irrelevant, notwithstanding the fact that they were assessing against the same words of purpose A, exactly the same formulation of purpose A, whether land contributed strongly or moderately to that purpose. Notwithstanding that. Yeah, that's your position.
Yes, that's my position.
All right, that's understood. So that's informed your judgment, obviously, about the degree to which this land does or doesn't contribute strongly. You say other things that I'm going to come to. As a matter of fact, obviously, Arup, in their stage 2 work, as we know, found that the area that includes the appeal site did not perform strongly either in purpose A or purpose B. That's correct, isn't it?
Yes, because it wasn't considered to be a town, it was a village, so they didn't even consider purpose A.
Yes, and in purpose B also, I think it considered moderate,
no,
exactly, not strong anyway.
Not strongly.
No. All right, thank you. And applying the new tests, as we know, are you still with Mr. Cannon's
I am, yes.
View. He takes into account, doesn't he, the barrister who represented the council last time, what the Arup study found in relation to Purpose A and Purpose B, 22A.
Do you mean last time at the last appeal?
No, if you look at paragraph 22, he says, as both opinions point out, the Arup study didn't find that the parcel within which the land sits made a strong contribution to Purpose A and B, and then he's got his points B and C, and then at 23 he says, I can't disagree with either opinion to the effect that the above three facts constitute a very strong case that on a further appeal an inspector would be likely to find the site's grey belt. So Mr Cannon is taking into account, isn't he, not disregarding as you do what Arup said about the contribution of the sites?
No, but he didn't have the benefit of my evidence.
Well, he didn't have the benefit of your evidence, that's right, that's true, but I'm pointing out to you, and it's just true as a matter of fact, isn't it, that he has taken Arup into account and you have disregarded it, as you told us, correct?
He has.
Yeah.
Whether that's correct or not is not my judgment to make.
Right. I mean, I'll take this up with your planning witness, but in the statement of common ground, it is agreed that the draft local plan evidence base, which includes the Arup work, obviously, in this connection, is a material consideration now. So that's actually agreed by your planning colleague in the statement of common ground at paragraph 4.4, sir.
I think it's a material consideration in terms of how the site was assessed within the last appeal.
No, that's not. Forgive me, we're at cross purposes. Just so that we don't go wrong, let me just make sure that we're on the same point. So, in the statement of common ground your colleague has signed on behalf of the council, the Arup work, the evidence base for the local plan draft allocation, is agreed to be a material consideration on this appeal for this inspector.
And we are considering it, or have considered it.
But you haven't. You've just told us that you think it's irrelevant. You just told us that.
I have.
Right. So inconsistent.
That's because the differences of policy now compared to then.
Yeah. What are we to do with this, though, Ms Backer? I mean, you've got two witnesses at the inquiry, and you're saying different things about that point by the look of it. Your position on the Arup relevance is
I'm
different.
I'm a landscape witness, not a planning witness, so I think that has to be referred to my colleague.
Okay. No, obviously I'll come back to that with your colleague, but let's let the inspector note, I guess, that insofar as you've taken a view about the relevance of the Arup work on this first main point, it's inconsistent with the statement of common ground that the council has in fact signed. Is that right?
It would appear so.
Yes. All right. Now, other than do you see, are you still with Mr Cannon's paragraph 22? I'm just using this as a way of navigating between the points. So the Arup study, and then he refers to the inspector in January 2024. Again, are you saying the same thing as far as your judgment is concerned, Ms Backer, that Mr Fagan's view that the land in question, the site, makes a moderate contribution is irrelevant for our inspector? Is that what you're saying?
The term irrelevant is not correct. I think it's something that we should be considered, but again, the test for grey belt was not the one in front of Inspector Fagan, so it begs that there's a different set of questions and tests now. So have you, again, just to be absolutely clear, did you take into account what Mr Fagan said when reaching your view? I have, but I have taken a different view.
And how much weight did you give to what Mr Fagan said on this point?
Again, because policy is changed and the test is different, it can only be taken lightly. Lightly, okay, I see. All right. Obviously you came in, and then the third point is no evidence, do you see at 22C of Mr Cannon's opinion, there's no evidence supporting a conclusion that the land makes a strong contribution to any of the three relevant purposes. Now obviously you say, well, I've given some evidence, and Ms Brown gives evidence and so on at this inquiry, but when the members rejected what not just Mr Cannon was saying, but what the officers were recommending in the report,
they didn't have any evidence at all, did they, in front of them, making a positive case that this made a strong contribution to purposes A and B?
No, they did not.
No. All right. And then you came in, you tell us in your proof, to do the appeal. I think your evidence obviously is dated on the exchange January 2026, isn't it?
It is.
Yeah. And you tell us you were appointed to assist at this appeal. When did you first go to the site?
In November.
In November. November 25.
That's correct.
Okay. All right. And when you went to the site, did you go on to the site, into the middle of the site? Or
I
not?
didn't, no.
You didn't. Okay. So when you went to the site, you were on the public domain, were you?
Because in terms of the LVI and visual issues, we stick to public viewpoints.
Stick to public
I did look through the edges of the site and got a good sense of its character.
Yes. I see. Okay. All right. Okay. So in relation to purpose A, just turn to the guidance, would you? So we've got that, I think, at core document 3.9. I say the guidance, I mean the PPG guidance. Is that one of the ones that's open?
No, it's not. Unfortunately. I'm fairly familiar with it, so you can start.
No, I'd like to wait till you've got it open, Ms. Backer.
Did you say 3.3?
3.9.
3.9, sorry. It's nearly there. Right, I'm in.
Are you there?
I do have the document in front of me now.
You got it, okay,
Yes.
great. If you go down, please, to PDF page 4, that's where we have the section, which is the paragraph, which is entitled, How should the contribution land makes to the relevant Greenbelt purposes be assessed?
Mm-hmm.
Yeah? And the first one is purpose A. Now, first of all, I take it that you agree, do you, that the PPG guidance here, I take it from your earlier answers about change since 2024-5, is a very important material consideration for the inspector?
I do.
Okay. And I take it that you also agree that when one's interpreting and applying the PPG, one should do so that it's internally consistent.
I do.
Right. Thank you. The purpose, as we've known, obviously, as I said, the words haven't changed, is to check, isn't it, purpose A, what's described as the unrestricted sprawl. Yeah? So not just sprawl or development, but a particular formulation that we know and love over many years, unrestricted sprawl. Yeah?
Yeah.
And you'll be aware, I'm sure, from your work before December 24 or February 2025, judgments about whether land was important to check the unrestricted sprawl needed to take into account the extent to which any development would be contained. Because that's where the word unrestricted goes, isn't it? Yeah.
It's just one part of the meaning,
Yeah,
yes.
but that's what the unrestricted means. Not just sprawl, but unrestricted sprawl. Yeah. You're aware of that, presumably, over many years.
Aware of that concept, yes.
Right, thank you. All right. And when one turns to the guidance that was given in February 2025, I'll leave aside, for present purposes, as you know, we're not going to bother arguing about villages and large built-up areas here. We're just going to, whatever judgment the inspector reaches about that, your own judgment, sir, but we're not going to debate that here in front of you. It's not much point. Here, the illustrative features that indicate for the government a strong contribution are likely to be free of existing development, and the site is free, as you point out, of existing development. Is that right?
That is correct.
But it goes on, doesn't it? And so likely to be free of existing development and lack physical feature or features in reasonable proximity that could restrict, bearing in mind unrestricted sprawl, restrict and contain development. And you understand why that part about physical features restricting and containing is there, don't you, Miss Backer?
I do,
Yeah.
yes.
Well, why is it there? Why is that an indicator?
To consider the visual impact of a site, because features can physically stop a visual perception of a development.
Yes, physical features in reasonable proximity could restrict and contain development, because obviously if there weren't those features, what would be the result, potentially?
That they would restrict
That they-
development.
Yes, but if there weren't such features, what would be the effect, potentially, on the green belt of a development of 195 houses on a site? If there weren't features to restrict and contain development, what would be the result?
It would contain them.
No, we're at cross purposes. If there wasn't a feature that restricted and contained the development, what would be the effect if there was no such restricting feature?
It would contribute sprawl.
It would
Contribute to sprawl
because
it would be visually.
right. And would there be anything to stop the next field potentially being developed in that case?
Probably not.
Probably not, exactly. So if you've got a feature within reasonable proximity that could restrict and contain development, then obviously developing the subject site wouldn't have that undesirable potential consequence, would it, of leading to the next field and then the next field and then the next field? Yeah?
That's possible,
Okay,
yes.
all right, thank you. All right. Now, the point that you make, just as a matter of approach, Ms. Backer, about the soft green edge, yeah? The site, you say, it's open and it's a soft green edge to the settlement, yeah? That's one of the things you say, in your view, means that it strongly contributes to the purpose A, yeah?
It is, yes.
And there you're referring to the openness of the pastoral field, yes?
Yeah.
And I think to some extent, not just to the grass on it, but to some of the trees that are on the edge of the back gardens and so on of the houses themselves, yeah. Now, Would your answer be the same if instead of the woodland, one had, for instance, the M1 on embankment, a major road? Would you still say that the site performed strongly because of the openness of the site and the trees on the edge?
It would not have a rural character if it was adjacent to the M1.
Right. Well, I think you were talking, I took you through it carefully. Your case is, look at the intrinsic nature of the site. It's a pastoral field, it's open, and it forms a soft buffer, I think you said, to the edge of the settlement. Now,
The site itself does.
The site itself, that's right. That's why you say the site itself performs strongly against Purpose A. Would it perform strongly, bearing in mind nothing changes, open pastoral landscape and trees on the edge of the back gardens, were there to be a major road on embankment instead of the woodland?
It would still be intrinsically open.
Well, that's not my question. Would it still, in your view, perform strongly against Purpose A, yes or no?
I'm not sure.
You're not sure?
I'm not sure, no.
Well, you wouldn't do, would it? I mean, if the M1 was where the trees are in the plantation,
Because
that would obviously be, wouldn't it?
That would affect its character. So you would see the character in a different way. You would read the site in a different way.
You would read the site in a different way.
The
Okay.
site is framed by woodland, which is a characteristic feature of the landscape.
I see. So do you, when you're interpreting and applying the guidance in this paragraph, exclude blocks of woodland from the words physical features?
It is a physical feature, but within the context of this site, it is not a feature of the site, because the site is open and only framed by this woodland, which is part of its landscape character, the character of the wider landscape. And I think it reads completely differently because of that.
Okay. Well, let's just come back to my counterfactual example, if you like. A major road on embankment would be a physical feature, wouldn't it, if it was where the plantation was, that would be in reasonable proximity and would restrict and contain development on the site, wouldn't it?
I guess so.
Right. Yeah, I mean, well, let's be fair, Ms. Backer, it would be, wouldn't it?
It would.
Yeah, not I guess so. And the same is true, isn't it, of the woods. They're a physical feature, as you accept. They are in reasonable proximity, aren't they? They're right on the edge of the site. In fact, in the site in some parts.
In some parts, yes.
Okay, so they're in reasonable proximity, and they restrict and contain development, don't they?
They do, but they also contribute to the character of the site.
Okay, thank you. So you say they contribute to the character of the site in a different way, I accept, than, say, the M1 on embankment would, but we're at the point where we have a physical feature, the woodland, in reasonable proximity that could restrict and contain development. Now, having agreed all of that, we don't find that acknowledged or accepted in your proof at all, do we? What we've just agreed?
Because I see the site differently.
Yeah.
I don't see it I see the woodland as part of its character that frames it, with the site being the important open part, which is its role, is restricting the sprawl of development rather than the woodland edge.
I understand that, but my question was a slightly different point. We've agreed what I've just put to you. The inspector's heard that, no doubt. And bearing in mind that we agree that the woods are physical features, they're in reasonable proximity, and they could restrict and contain development, why is it, Miss Backer, that you have not taken that into account? The fact that this key part of the PPG guidance tells you that it's unlikely to make a strong contribution.
Because I feel that there should be a more nuanced judgment than a simple yes or no answer.
Sure. But you would accept now, wouldn't you, having gone through that exercise, that the bit about and lack physical features in reasonable proximity that could restrict or contain development itself, on its own terms, indicates, doesn't it, that the site falls within that category? this guidance applies, doesn't it? That part of the guidance applies to this site.
I mean, you can't deny that it has a form of containment. It does conform. However, the site's intrinsic character is nothing to do with the woodland.
Yeah.
So I think that's where we are having a difference in
That's
view.
right, but that's about intrinsic landscape character and not about this no development spatial strategy, which is spatial policy, which is what Greenbelt is about. It's not about landscape character, is it, Greenbelt?
I think it's an important part of it, yeah.
I see. That's where you get that point in the Greenbelt context. But anyway, I put the point twice about why it's not in your evidence. You've given your answer. The inspector's heard that. The other point that you make relates to the next part. It says they are also likely to include, are you still with the guidance, all of the following features. And the first of the ones we're not arguing about at this inquiry, which is being adjacent or near to a large built-up area. But the second one, if developed, it would result in an incongruous pattern of development, such as an extended finger of development into the greenbelt. You see that one?
I do.
Yeah. Just have a look, would you, at your proof, just to help us on this with an aid memoir. So in your proof, PDF, so that's PDF page 11 of core document 6.12. So.
11.
So that is your inset map 2 when you get there.
Yep.
Okay, so bear in mind what we're thinking about here is would developing this site be incongruous, set up an incongruous or create an incongruous pattern of development such as an extended finger into the greenbelt. Now, Radlett, not all of Radlett's obviously shown in this excerpt from the OS plan that you've marked the topography ridges on, but we do have the bit that's in proximity to the site, don't we? And we can see that section of the town has grown up, hasn't it, in an area that was, I think, part of a former large house in its estate, between two roads. Can you see?
Yes.
Theobald Street and Shenley Road, Radlett Road. Yeah, we can see them. They're in yellow, luckily for us, on that plan. And we can see, can't we, that this bit of the settlement's extended into that area, in the area between those two roads, correct?
That is correct.
Okay, and it's extended over time, obviously in the 20th century, onto a sloping bit of topography. Yeah, and it's resident. Is that right? Yeah, onto sloping topography.
It's very
yeah,
sloping. Yeah.
And the site is sloping, isn't it?
Slightly sloping. It's quite steep in places.
Yeah. Well, you can tell that when you go on the site, Ms. Backer. It's residential, isn't it? So the pattern of development here is not great big chunks of kind of primary scale or big kind of figure ground buildings and big curtilages and so on. It's a 20th century residential layout, isn't it, in this part of Radlett?
It is.
Yeah, okay. All right. And the site is not just enclosed by the two roads, but it's also hemmed in by the woodland we've been talking about, and indeed the older non-plantation bit, which runs along the road, Theobald Road to the south, Theobald Street to the south. Yeah?
I wouldn't say it's hemmed in because the scale of the site is quite large and it still has a very open feeling when you're within it.
Right. Okay. And so if the question is, if it was developed, would the development result in an incongruous pattern? Yeah? Is this right? When you're trying to answer that question, you've got to identify, first of all, what the pattern is that's there at the moment.
I would agree.
Yeah.
We have a very low density development within the Newbury estate with large gardens, verdant character, lots of trees.
Yeah. Okay, so I think you were running ahead to answering the question. I was still being a bit pedestrian, sorry, and asking you what the approach should be. So you ask yourself what the existing pattern is, and obviously the guidance, would it resulted in incongruous pattern? Incongruous means different in a pejorative way, doesn't it? I mean, different and jarring, if you like, incongruity. Yeah?
Yeah.
Yeah, okay. So would it be different and would it effectively be jarring compared to the pattern that's there now? So we've got 20th century residential development developed between two roads, which are the two roads on either side of the appeals site, and it's residential development which is being proposed here in an estate form, outline obviously at the moment. So none of that is any different, is it, in principle, in terms of pattern from what we've got already there?
I think there'll be a difference in terms of the density, the height of buildings, that would be incongruous in this location.
So I think one has to bear in mind, I'll come to your point about density, but one has to bear in mind, doesn't one, that the point here is about the pattern, isn't it, of development, and not, as it were, kind of poking out into the green belt. And here, it wouldn't poke out, would it? Because it would be advancing between these two historic roads on either side in just the way that development in Radlett has done over the past 100 years, wouldn't it?
But it's of a completely different nature.
When you say but, do you mean yes, but the density would be different?
Yes.
Right, thank you. Okay, so obviously density and scale, I'll put a note, I will come to that, Ms. Backer, in just a moment. You don't suggest, I think, in your evidence, do you, that the site would be like a finger poking out into the green belt, do you?
That's not the way I read the word incongruous.
Okay. There is... yes, okay, fine. You don't say that because that's not how you read it. All right. And just coming to your point about scale and density, so I just want to show you what you wrote here. Just go, would you, in the same, we're in your proof, I think, already, aren't we, looking at this image. If you go, please, to your 9.4.10, and so in PDF terms, that's page 52, I think. 9.4.10.
Yep, got it.
And so the preceding paragraph is about make a judgment and so on. And you say, to the above I add that it's important to appreciate scale and density when considering whether a development will result in an incongruous pattern of development. Now, in terms of scale, do you mean height or how much development there would be overall?
Both.
Both, okay. All right, so we know, don't we, that the outline scheme and the numbers, indeed, up to 195, are based on 2 or 2.5, if you want 3, but we know what we mean by 2.5 story development, correct?
That's correct.
All right. So you're not saying, I think, that they'd be so high they'd be out of character. You've been to the area, you've seen all the houses with all their loft extensions and Velux windows and mansard roofs, haven't you, in the area?
They're still very visually screened from the settlement edge.
Sure. Well, okay, that's a different point. But if you're saying that the difference here is to do with scale and height, you're not, I think, suggesting there's any evidence that the heights of the buildings here would necessarily be completely out of kilter with the heights of the buildings that one finds in the Newberry's estate, are you?
Bearing in mind that there are areas of bungalows.
Yeah, leaving aside the bungalows. But the bungalows, we know, have got specific areas marked on drawings and so on. You've been there, the inspector's been there. Most of the houses are not bungalows, are they, in that area?
No, they're not.
No, okay. And so just come back to my question. You're not saying, are you, that what's proposed here would be, and let me put it this way, radically different in terms of height from what one finds in the existing area?
I think they will be, yes.
So your judgment is based on thinking that the buildings proposed would be of radically different height. Okay. All right. Now, obviously, we've got indications about what storey heights are proposed and so on, and unit numbers. That's all a matter, isn't it, for reserved matters?
It is.
So what heights, and indeed whether it's 2 or 2.5 stories or etc., that's all controllable, isn't it, by the local authority?
It's all
permission is
within the
granted?
parameters that have been set out,
Yeah.
though.
But for instance, full 3 versus 2.5 rooms upstairs in the roof, etc., those are all matters of detailed design, aren't they, that the local planning authority would be able to control?
That's true.
Okay, all right.
Within the parameters that you're providing.
Yeah, within parameters. And so your point about density, again, I don't want to get hung up on I think you mentioned, did you 11 dwellings per hectare in the existing area? You're not suggesting that it would be appropriate to grant permission for 11 dwellings per hectare on a site in 2026, are you?
I'm not sure what the figures are on the existing and the, but it will be denser.
It will be denser, but what's the point here? That it will be slightly denser, slightly tighter, slightly closer, because the houses might be slightly closer to each other. But the inspector needs to reach a view based on what the houses in the existing area are like, doesn't he?
Mm-hmm.
And have you now been onto the middle of the site and had a look at the backs of the buildings that face onto the site, onto the site? Okay, and you've seen that those houses are all, for reasons one can understand, pretty tightly up against each other. There aren't many gaps, are there, between those buildings? They occupy, most of them, pretty much the full width of their plots backing onto the site.
Yeah.
Yeah.
Okay.
Okay. All right. So it's not as one views it, the interface, if you like, between this existing residential area and what's being proposed. An existing area which is characterised by buildings which are perceptibly have lots of space around them when one sees them.
And trees.
Right. All right. Was that a yes? They don't have a lot of space around them, do they?
But still within big plots and have large rear gardens with trees. So I think you have to take that into consideration.
Okay. All right. Thank you. I'm going to turn to purpose B. So just go back, would you, if you've still got it open, I hope, to the PPG guidance. That's in core document 3.9. And I want to turn to purpose B, which is just on the next page, please.
Yes, I have that.
Okay. Now, purpose B, again, wording not changed over many, many years. It is to prevent, isn't it, neighbouring towns from doing what?
Merging.
Merging into each other. What does merging mean?
Getting closer together.
Well, merge doesn't mean get closer together. Merge means to, if you merge with another company, you don't get close to it. You, what?
Join together.
You join it, exactly. You join them together. Merger means joining together. So purpose B is about preventing neighbouring towns from joining into one another, which is why when you look, Ms Backer, isn't it, at the illustrative features under strong, one is asked to consider whether the land in question forms a substantial part of a gap between towns, and also, if it were developed, it would be likely to result in the loss of visual separation. Yeah? Mm-hmm. The loss of it. Yeah. Okay. All right. Now, in terms of this particular case, the inspector has got various drawings and so on about this matter of judgment, as you and all the other witnesses observe. It is, let me take you, just bear that in mind, leave that one open if you can. Could you go to the statement of common ground, the main one between the council and the appellant, which is CD 6.4, please? Tell me when you...
Statement of common ground, yeah.
Do you have that one?
I do.
Yeah. In that document, if you wouldn't mind going to paragraph 4.15, 4.15.
Oh, sorry, this is the landscape statement of common ground.
6.4. I'm going here because it's just a factual point, you see.
No, I don't have it open.
You with me? So if you, it's PDF page 9 of 20, I think, paragraph 4.15, referring to some extracts of maps that are at the appendix 3 to this document, illustrating the gap between Radlett and Boreham Wood.
I know the one.
You know the one I mean. Now, first point, in terms of the application of Purpose B here, the council and the appellant have been looking, haven't they, at that gap, the one between Radlett and Boreham Wood, not the gap between Radlett and any other town or settlement.
That's correct, not Shenley.
Okay. And so, appellant agrees Radlett's the town. We've got some map extracts. It's agreed that with the development in place and acknowledging the Organ Hall permission at Boreham Wood, there would be a gap of 1.36 kilometres between the two settlements. Yeah, that's the agreed factual position, isn't it?
That is correct, yes.
Right. Okay. And we know, don't we, that I think there is the inspector can form a view about this, or if necessary, we can agree it on a drawing, so it might be a bit tedious, but the site varies, doesn't it, between about 115 to 160, maybe just up to 200 metres at its very deepest, in terms of how far away from the existing urban edge it goes.
That's correct, yes.
Yeah. So that's that diminution. So between 100 and say 200 metres in depth, further development. That includes everything right down to the edge of the red line of the appeal site. And just thinking about that, 100 to 200 metres, leaving a gap of 1.36 kilometres. You would acknowledge, I take it, that the site does not comprise, given that it's only that deep, a substantial part of the gap between the two towns.
It's the way that the site performs on the approach to the settlement. The settlement has a very green, verdant character, and you're not aware that you're coming into the village of Radlett on the approach from Shenley Road. I think the perceived gap is much larger than the physical gap.
Okay, let's take it in stages, and again, obviously in the end the inspector will give such weight to all these various points as he thinks appropriate, but just in terms of how big a proportion, just physically, in quantitative terms, the site is. Your answer indicates to me that you acknowledge, doesn't it, Miss Backer, that going another 100 to 200 metres further away, leaving a gap of 1.36 kilometres, means that the site is not a substantial part of the gap, correct? In quantitative terms.
It's still perceived as a very important gap between the towns.
That's a qualification to the answer that I think you're almost on the verge of giving us. Would you mind just answering the question and then qualifying it? It's not a substantial part, is it, that amount physically or quantitatively, but you've got your perception point, is that right?
Yes, that's
okay,
correct.
thank you. All right, so on the perception point, likely to result in the loss of visual separation, yeah?
Yes.
Now, as I said before, the words of the guidance is obviously pretty clear, isn't it? Likely to result in the loss of visual separation. It doesn't say, does it, likely to result in the weakening or erosion or diminution. It is pretty blunt, isn't it? It says, if you develop the site, it's likely to result in the loss of the separation visually between the two settlements. Yeah? That's what it says.
That's correct.
Yeah, all right. And obviously, one wouldn't, with the scheme in place, lose the sense visually that there were two different places, would one?
No.
No. And the inspector will have seen this, but there isn't a place, is there, where the appeal scheme, if you like, and Radlett would be intervisible with Boreham Wood?
Not that I'm aware of,
no.
no.
All right. Thank you. Now, Landscape and visual matters, I can deal with a little bit more quickly, given what we talked about at the beginning of these questions. It's just after 4, so I'm going to carry on unless you'd like a break, or unless Ms. Backer needs a break. Are you happy to go on, Ms. Backer? Okay. So landscape and visual. This point about the sensitivity of the appeal site in landscape character terms, that is, and the inspector will be aware of Glivia 3, the sensitivity in the methodology is partly derived from the value, isn't it, of the site?
The methodology.
The sensitivity of a site is partly derived, isn't it, from the value ascribed to the site? Yeah.
That's correct.
Okay. And here we know, don't we, that, again, it's all agreed and all done and dusted, as it were, last time in the previous decision letter. The landscape isn't a designated landscape, is it, in landscape character terms?
It's not, no.
And we agree that it's not a valued landscape in a kind of non-designated sense either. That's agreed, isn't it?
In terms of the MPPF, no.
Yeah, in terms of the MPPF. But obviously, not being designated, one might say, well, that's a very high level, a very high value, not that. Valued landscape, obviously higher value, but not quite as high as designated. But the fact that the site is agreed to be neither of those things is relevant, isn't it, to the value to be ascribed to it as a piece of landscape?
I don't believe it is, no, because that you can have landscapes that are not designated that still have value.
I'm not saying that I didn't say that there's no value. I just said the fact that it's not designated and it's not a valued landscape is relevant when one is considering how much value to ascribe to it.
Yes.
Must be, mustn't it?
Yeah.
Okay. All right. I mean, overall, there's not an absolutely enormous difference between you, which is why I'm going to take these questions in the way that I'm intending to. Do you have Ms. Brockhurst's rebuttal there? That's core document 6.15.
I have that.
6.15, sir. Tell me when you're there. I'm on page 4 of 12, sir, if you're looking at that document, where there's table R1.1.
Yes, I'm
Thank you very much. Sorry, forgive me, I was waiting for you to say. Okay, so the reason for taking you here is that, if you like, this kind of, to use a colloquial expression, cuts to the chase, doesn't it? Because it looks at the assessed effects at year 15. And you made a point, obviously, in your evidence in chief about what about year 1 or what about year 10. But the reason Glivia and the Landscape Institute looks at year 15 is because it gives the decision maker a sense, doesn't it, an assessment at that time of what the a scheme with its more mature landscape would actually be like, the residual effects, if you like, yeah?
That's correct,
okay.
Yes.
And in the end, isn't it more important to consider what the residual or the kind of long-term effects of a scheme would be rather than what it might be for the first few years?
10 years is quite a long time, so I think it's a valid point.
I didn't say it wasn't valid, and I didn't say 10 years is a long time. I tell you, my 2 daughters are only 9. It's been an enormously long time, I can tell you. But I'm thinking about what's more important. That was my question. I mean, obviously, we get to year 10 and then to year 15. You know, schemes like the existing housing that we've got there can be there 100, 200, 300 years, can't they? So it's more important is what the residual effect would be. Do we agree?
It would.
Yeah, okay. Thank you. All right, and here we can see that In terms of the receptor that I'm particularly interested in, which is the grassland, the pasture, and the overall character of the site, we have the same, don't we, as between the council and the appellant, substantial adverse in relation to year 15 for land use and moderate adverse overall character of the site. No difference in the end as to the output, correct?
Yes, we
Yeah.
do.
Okay.
But?
But?
No, go on.
Okay. All right. And so just as I wanted to put that because it gives one the sense of, as it were, how much we should be fighting about these things if we actually agree in the end what the most important long-term residual effects would be on these two things. The difference on value which feeds into sensitivity, can I just take you to your proof? So core document 6.12, sir, and your paragraph within your proof 6.1.2.
Of my proof?
Yes, of your proof. 6.1.2, sir. It's on PDF page 28.
Yep.
So you're talking there about the LVIA assessing the value of the appeal site, landscape value assessed at medium, the woodland to the south, medium high due to its wildlife interest, contribution to local character. Yeah? You with me?
Correct. Yep.
Now, in your approach, to these categories of value, low, medium, high, do you have anything higher than high, as it were? Is that the highest category?
I use the same methodology
Yeah.
as proposed in the LVIA.
So high is the highest value?
Yes, it is.
So high value in landscape terms would, okay, it might be quite a big category, but it would include things like national landscapes and valued landscapes and so on.
That's correct.
Right, okay. So when one's approaching the degree to which there's a difference, when one's thinking about medium to high or medium versus high, one has to bear in mind the way that these scales are calibrated by both you and the LVIA expert, correct?
That is correct.
Yeah, okay, thank you. All right. And then the reasoning that you give, if you go to a couple of pages further on to your table 1 that you took us to in your evidence in chief. So this is on PDF page 30 and following.
I have it.
The difference there in that first one, sensitivity high, land use, grassland field, appellant's assessment of sensitivity medium. Your point, or certainly what seems to be right up at the top there, and is the one that you repeated in your evidence in chief, is not just that it's a pastoral field, but it's the last pastoral field before the woods enclose it. That's what you said in chief, remember?
That is correct, yes.
Okay. So is that isn't in fact, I think, is it, the fact that it's the last pastoral field, etc., something about the intrinsic nature of the pasture? That's a kind of contextual point, isn't it? That beyond it there are woods.
Yeah.
Right. So the fact that it may be the last one, if you want to put it that way, or next to it there are woods and there aren't any pastures next to it, is a point not about the intrinsic nature of the land use and the grassland at all, but about its context. Isn't that right?
Yes.
Right. I see. Fine. In terms of the grassland itself, again, its pasture and so on, it's characteristic, I think, isn't it, of some of the pastoral grasslands one finds in the landscape character area. There's nothing otherwise particularly special, is there, or value-laden about the grass itself, the grassland itself?
Not in ecological terms, but I think in its character, that contributes very positively to the character of the site.
Yeah,
And
it's an open grassland. Yeah, open grassland. Okay, that's fine. But in terms of how sensitive it is, you again, I think in your and the LVIA approach, high sensitivity is the highest category, isn't it?
It is.
Yeah, so it's you know, the triple SI in the middle of a national landscape would be high, wouldn't it? On this scale. Yeah.
I guess it would be.
Yeah. So just as a matter of judgment, bearing in mind that your point about last field is a contextual point rather than a point about the intrinsic character of the site, and the fact that one has to approach, doesn't one, these scales in a reasonable way, would you accept that a reasonable landscape assessor might find this site to be of medium sensitivity rather than high sensitivity?
I would think it's definitely on the high end
of
medium, so
high
medium to high, and I think that's how I look at it when I look at the overall character.
Okay. All right, well, there we are. Okay, now I want to just take up one point with you that you will have seen perhaps today, I don't know, the inspector will have seen certainly, that you make a point about visibility as part of character, so what you can and can't see, and I'm not suggesting that's wrong. Obviously they're separated in terms of receptors in a different way, to which I'll come, but you make a point about winter views versus summer views, yeah? And say, well, you know, LVIA, summer views and not winter views. But it's right, isn't it, that when one's on the site in the winter, the backs of the houses in the existing residential area are materially more obvious, aren't they, than they are in the summer?
I'm basing my conclusions on the photographs in the LVIA, which were summer views.
Yeah.
However, the views that we looked at this morning, which were in winter,
yes,
are similarly verdant in character. I think that especially in the views from Shenley Road, where you really hardly see any built development.
Right. So do you mean that, take it in stages, from Shenley Road, no real difference, whether you're looking in the winter or the summer?
Yeah.
Right. So
maybe in terms of the hedgerow at the front, I think that has an effect of having some screening ability or more screening ability in summer.
Okay, but leaving, I don't want to joust with you about winter and summer views. The inspector's seen it in its worst case, hasn't he? He's seen it in the winter when there are fewer leaves on the trees.
Yeah,
and you've been on the site, the inspector has. You can't but get a very clear view, can you, of the backs of the houses in the existing residential area from the site in the winter. That's just a matter of fact, isn't it? Yeah. All right. Okay. So would it be fair to say that in the winter, the effect of the urban edge, if you like, on the character of the appeal site is more marked? Because you can see more of them more clearly? Yeah. Okay. Thank you. All right. And then the other points I want to take up with you about this, again, just focusing, proportionately, I hope, on this question of sensitivity, is can I just be clear, do you say that this point about local nature recovery is directly relevant to the question of landscape sensitivity or not? Or do you say that it's another relevant point?
I do think it affects the sensitivity of the site and its susceptibility to change more specifically. Okay. And I think it indicates, the potential value of the site for nature recovery.
Okay, so the answer to my question is yes, I do. I do think it's relevant. I've taken it into account in the view that I've reached about sensitivity in landscape terms of the site. If you just have a look at your proof, then please. We're in it with the table, but if you wouldn't mind going to page 20, please, and paragraph 3.4.2. 3.4.2. So this is in PDF, page 20, under the heading Hertfordshire Local Nature Recovery Strategy. Page 20.
I'm there.
You with me? We can see what you've referred to there in 341 and 342. And you say there the LNRS aims to reverse nature's long-term decline of biodiversity by identifying and mapping priorities and locations for creating and improving natural habitats. Yeah? And obviously the inspectors no doubt had a look at that. That's what it does. So a couple of things arise from it. Firstly, the the expressed aim of the local nature recovery strategy is not to safeguard or improve landscape character per se, is it?
Safeguard.
Sorry?
Did you say safeguard?
Yeah, safeguard or improve landscape character. As you've told us, it's about creating and improving natural habitats, isn't it?
That's correct.
Okay, so it's not a landscape, to whatever it is, it's not a landscape designation, is it? LNRS.
I mean, ecology and biodiversity networks are intrinsic to landscape character, so I find it difficult to say no on that question.
Okay, well, I put it in a particular way. I didn't say that ecological matters could never be relevant to landscape. I was clear, I hope, in my question. Because a site may feature in whole or part in an LNRS, that isn't a landscape character designation, is it?
It is not a landscape character designation.
Okay, all right. It's, as we know, it's about, as you've told us, mapping priorities and locations for creating and improving natural habitats. Now, in the case of the Hertfordshire one and in relation to this site, it's about, isn't it, what could be done in the future rather than the value of what's there at the moment, correct?
Yes, that's
right.
correct.
Okay, it's not about the sensitivity or the value of the site, even in ecological terms at the moment. It's about what could be done in the future there, correct?
It is.
Right. Okay, and the ones in particular here, neutral grassland and woodland, yeah, they're the important ones. Okay. Now, we know, don't we, that there's no dispute between the council and the appellant about the over and above statutory requirement biodiversity net gain that the scheme will bring, correct?
Correct.
That's in, again, for your notes, 4.19 of the Statement of Common Ground. And when you've been considering this point and the sensitivity issues and so on, have you taken that point into account, that there'd be a circa 20% biodiversity net gain the site as part of the scheme?
Yes, I have, and that's evident in my assessment of effects.
Thank you.
So it reduced the substantial effects that were recorded.
Yeah. But what you do, if you are still with your 3.4.2 in your proof, you talk about, you set out what the main aim is of the LNRS, and then you talk about wider environmental benefits and carbon sequestration and so on, and then you say 3.4.3, one of the key objectives is to promote nature recovery, highlight the best places where biodiversity and nature can thrive and promote wider environmental and societal benefits. And then you descend to the detail and you give us extracts, layers, if you like, from the online tool, don't you, that we can link through to from the appendix. And that's where we have our neutral grassland in brown and broad-leaved woodland in green. But then you say 3.4.5, the identification of the appeal site for nature recovery, so this prospective point that we've agreed on, in respect of both woodland and grassland, demonstrates the appeal site's landscape and biodiversity value. Now, I think it follows from what we've agreed, Ms. Backer, that the height of what it can demonstrate is the potential improvements that could be made. Is that fair?
I think that's fair, actually,
okay.
Yes.
It doesn't actually go, does it, to the value or the sensitivity of the site as it stands today? Yeah, thank you. All right. Goodo. Now, just in terms of final question on value, before we wrap up, a couple of final points on character. On value, you've seen Ms. Brown's evidence, I take it?
I do.
Read that? Yeah. And you've seen that what she ascribes in terms of value to the site?
I have,
Which is in accordance, I think, in agreement with Ms. Brockhurst, isn't it? Medium value rather than medium high?
It was, I think, yeah.
Yeah.
But she still recognises high susceptibility.
Yes. But in terms of value, she's at medium, isn't she?
Sorry?
She's at medium, isn't she, in terms
so,
of value of the site? That's 5.10, so if you'll note of core document 6.14, 6.14, paragraph 5.10. Okay, and then just before we leave this topic, can I just take you to Ms. Brockhurst's rebuttal, please, which is core document 6.15. So, and we looked at table R11.
Mm-hmm.
I'm so sorry, sir. So we're still on page 4 of 12 PDF. I should have checked before, forgive me, out of order at this point. Agreed, this table? I didn't hear in your evidence in chief any dispute with what it shows, what Miss Brockhurst is setting out about her case and the council's case.
Whether I agree.
Yeah, that it faithfully records her judgments and your judgments, doesn't it?
It does,
yeah.
but
okay.
it doesn't show the year 1 effect.
No, absolutely,
yeah.
Which is why I asked you about year 1. Okay, thank you. So that's the inputs, and I'll ask the same, obviously, in due course of the Rule 6. But as far as the council is concerned, okay. If we go, sorry to jump around, but I'm just trying to mop up the last couple of words. If we go back to your proof, please, 6.12, your proof, CD 6.12, and look at your table 2. So, PDF page 35. I just want to, if you're there, yeah, I just want to look at the, and again, I take your point about years 1 to 14, but I just want to look at level of effect year 15. So this is your assessment, isn't it, that we're looking at here? And you say substantial adverse for land use and grassland, and then moderate for topography, moderate for woodland and trees, moderate for hedgerows, moderate for overall character of the appeal site after 15 years. Yeah?
That is correct.
Slight in terms of the whole character area, moderate in terms of the townscape of Radlett. Yeah? Now, I just want to come back to what you said in your evidence in chief about what may or may not, in your view, be significant. I think you said, didn't you, substantial or moderate stroke substantial would fall into the category of significant. Correct? Remember?
I did.
Yeah?
Yes.
So if one applies that to your table 2, it would mean, wouldn't it, that it was only that top one, land use grassland substantial, that fell into your own category of significant. All the others on your year 15 judgment would fall below, wouldn't it, significant?
It does suggest that, yes.
Yeah. All right, thank you. And then just staying with your proof, I want to just deal very briefly with the question of visibility of visual receptors. So this is the last section of questions I've got, very short. And I do so, obviously, as you'll appreciate, Ms. Backer, in the understanding that nothing better than actually going and looking, which the inspector has done and or may do again. So if you go to your proof, please, at section 7, under the heading Visibility and Visual Effects, you say at 7.1.1, sorry, I'll wait till you're there, forgive me. 711? You there?
Yeah.
Yeah, 711, it's common ground that the visual effects of the proposed development on the wider landscape are limited. And you say why? Yeah? Due to the character of the site's surrounding landscape. And that principally, that bit about this character of the site's surrounding landscape is a reference to the trees, isn't it, the woods?
It is, yes.
Yeah. So, to put it in layman's terms, forgive me, a lot of trees in the way of any views more than limited effect. And I asked you earlier on, obviously, when we were looking at purpose B about intervisibility or otherwise between the two settlements. But I think it is fair to say, isn't it, that unless one is relatively close to the site on either Theobald Street or on Shenley Hill, one wouldn't see the site, see buildings on the site. Is that correct?
That is correct.
So
yes.
on Shenley Hill, you wouldn't see it until you came around the corner, would you? Right by the access.
Yeah.
Okay. And on the other side, you wouldn't see it until you were near the part of the site where that pedestrian and cycle access is proposed to come out. You'd have a view through there, wouldn't you?
Yes.
But you wouldn't see it from further south, would you, or southeast?
Not really, no.
Okay. And that's why you say it would be it would be limited in terms of localised might be another word to use. Is that fair?
You could say localised, yes.
All right. Okay, we'll leave it there. Thank you very much, sir.
I've only got, up to the witness, I've got about 5 to 10 minutes. She might prefer, if she would like a break, would you like to carry on?
I'd rather keep going so
I thought I
everybody can go
sensed
home.
she might keep going. So if you're content to keep going, sir, and everyone else is, thank you, I'll get on. Good, so don't relax. This is the dangerous moment. Keep alert. Now I'm going to go back and ask you about some of the matters you were asked about. Okay, going back to the beginning of the cross-examination, and we can go to some of the documents if you need to, but let's see if we can just deal with it without. First of all, you were asked about the minutes. Do you remember the minutes of the resolution to refuse this? And you were taken to them at Court Document 2.1. The point was made to you that it doesn't actually mention landscape in the minutes. It does mention the very special circumstances test and the balance, but you accepted that. Now, in the reason for refusal, which is the formal expression that members give and resolve for the refusal, does that mention landscape?
Yes,
harm?
it talked about the identified landscape harm.
And again, if you can go to it if you want, but there's a statement of case the inspector has at Court Document 6.2, which is affirmed and looked at by the council as a matter of law, setting out their position for the inquiry. Does that cover landscape and issues that you addressed?
It did, yes.
All right, good, thank you. Now, you were also asked about the advice by Mr. Cannon, Court Document 2.6. Could you take that up, actually? Because you were taken to some parts of the advice, but not all. And I just want to ask you about some other parts of it as well, okay? And that's Core Document...
I've got it, yeah, 2.6.
Yeah, you have. I had it and now it's just disappeared. There we are. Right, got it. Good. So, again, I think the inspector's read it all, but I just want to give it some context beyond some of the points you were taken to. If we go to paragraph 7, first of all, and he says in his advice, before addressing each... and by each he means the various opinions that he's seen before, which I'm sure we'll look at later on in the inquiry. He says the question of whether land, paragraph 7, is or is not grey belt is not a question of law. It turns on the description given in national policy and augmented by guidance in the planning practice guidance. The question will usually turn on a series of planning judgments made about certain aspects of the definition. Both opinions essentially recognise that. And has it been your approach to deal with it as a matter of planning judgment?
Well, obviously, from a landscape perspective, so I think yes and no. Yeah.
Well, what I'm putting to you is that they're judgments to be made in each case.
They are judgments, yes.
Did Mr. Cannon have your expert evidence before him when he wrote?
No, he did not.
Did he have the expert assessment of Mr. Stroud, who's produced an assessment on the purposes for the inspector?
No, he did not.
Did he have the 2 expert assessments produced by the Rule 6 party before him?
He didn't have that.
No, so he didn't have any of those. So, when you look at Mr. Cannon's advice, and you look further down, and you look, for example, at paragraph 20, again, I don't think you were taken to this, but he identifies the question as being, the question is, he says, is what evidence there is about the contributions. He didn't have any of the evidence that we rely on for him today, and he wrote his advice, did he?
I believe he did refer to the Greenbelt assessment.
Yes, I mean the expert.
But we know that
my
is
loose question.
not
He didn't
relevant.
have any of the expert evidence I referred to just a moment ago. The assessments that this inspector has. Is that right? Okay. All right. And he then referred to, just to give again context of how he approached it, the three facts he sets out at paragraph 22. A is the Arup study, which you've addressed, and we'll come back to that again in a minute perhaps. B, the inspector in January didn't find the land make a strong contribution. And C, the fact, when he wrote the advice, that there's no evidence supporting a conclusion that the land makes a strong contribution. Is that a fact that still pertains today, or is there now evidence that supports the conclusion in your view?
No, it doesn't support today.
Yeah. So is there evidence that exists today that supports the conclusion?
Yes, our evidence.
All right, thank you.
Yes.
Now, again, just paragraph 31 of his advice, he he again makes the point that he doesn't have any cogent evidence before him when he makes his conclusions. Is that right?
Mm-hmm.
Yeah. Okay. Good. And I can deal with the rest of the points, I think, in submission. Now, moving on from that, you were asked some questions about the ARUP judgments, the ARUP assessments, and whether they were relevant and material. Could you take up the planning statement of common ground? And I'm not going to trouble you with what a material consideration means. I can deal with that in submission. Mr. Stroud will no doubt address what that means. But if you take up the statement of common ground, please, and you were taken, I think, my note tells me to 4.4 of it, because that's the bit that agreed, excuse me, 4.4 page 6, if one's looking at the hard copy, that agreed that sporting evidence base is a material consideration. I think that's the point you were taking to.
I haven't got it in front of me.
Okay, could you
You really
get
want
it?
me to have it, yeah.
I do want you to have it in front of you, please, because I'm going to take you to other parts that you want you to look at.
So slow. I have to say I apologise for this.
Has anyone got a copy? No? No.
Some core document number was?
It is core document 6.4.
Oh, I've done it again. Press the landscape.
Let me deal with it this way, because it's better, just in the interest of time. There are, and I can take you to, there are three other paragraphs, 410, 411 and 412, that are also agree matters about the ARUP and how they should be approached between you. And one of the matters agree, the first one, it's about stage 1, it's commissioned by the council, identify the site as falling within a larger parcel of land, which perform moderately, and you address in your proof how material the larger parcel is in coming to your conclusions, and how, in your view, it won't therefore assist, okay? And 411, it says the stage 2 assessment undertook a more granular assessment, which comprised the appeal site and Newbury School. The assessment identified the assessed site does not contribute to purpose A, and only moderately contributes to purpose B. Then it goes on and says both ARUP assessments predate the introduction of the Greybelt concept and the guidance in the PPG. The inspector in the previous appeal disagreed with ARUP's findings, and that's right, isn't it? You've seen his inspector's report, which does that. Yes?
Yes.
And then it goes on, including those of the council, all opinions previously expressed by all parties predate the Greybelt concept. And so, material to that extent, and you, as you said in your evidence, so far as the more granular assessment, in terms of purpose A, did it even get to the stage of assessing the purpose at all? Or did it just stop because it felt it was a village or not a large building?
That was right. It did just stop.
So does it provide any assistance to the at all on the purpose, let alone the tests which didn't exist, which underpin the purpose?
I don't believe it does.
All right. Thank you very much. Now, in the next question, it was said to you, members, when they made their decision to refuse and come to the conclusion that there was a contribution or purpose A. Now, they didn't have any independent expert studies which now exist saying it's a strong contribution. Oh. Sorry. So it was put to you the members had no evidence before them, and it's right, and you accepted there's no evidence, there's no professional reports that they have now. And if you can't answer it, don't worry, I can deal with Mr. Stroud, but in your experience generally of members, can they be taken to have a sort of working knowledge of the area and what the site looks like in the area?
Do
Members tend to have a working knowledge of what the area looks like.
Yes.
Are they able, within their limitations and the roles they're given to them by statute and law, to form judgments?
Yes.
Yes. Is there now, in your view, evidence, not only from the council, but indeed substantive professional evidence from others before this inquiry that supports the views the members took?
Yes, there
Yes.
is.
Then you were asked about we're going to go on to talk about the purposes. You were asked about the MPPG, and you were taken up and taken to Core Document 3.9 and the various factors which that guidance tells us one should look at. And in relation to Purpose A, you had a discussion about the woodland and the role it plays in terms of restricting or containing. Do you recall that?
I do.
And there is that wording that you were discussing with my learned friend about Purpose A lacking, for strong contribution, lacking physical features and reasonable proximity that could restrict and contain. And you asked some questions about that. Now, again, if you're not aware of this, you weren't taken to one of the recent decisions and evidence for this inquiry about restricting the Marlow Secretary of State decision. Are you aware of that decision?
The
Marlow Secretary of State decision? If you're not, I'll ask Mr. Stroud about it.
I don't.
In which case, I'll park that in fairness and ask Mr. Stroud
that's
about
not one I refer to.
What the Secretary of State did in relation to that test there. You were asked about Purpose A, and you looked at your 9, if you can just turn up your proof at 9.4.9 of your evidence. And this is when you're discussing your position on Purpose A, and some questions were put to you about incongruity or incongruous in that guidance, and I think it was put to you, said it would not, in relation to the proposal, it said it would not poke out, would it? And you agreed it wouldn't poke out. But you said, in my note, you said it would, in your view, would be at odds, and you said it would be a development of a completely different nature. I think it would be read differently in relation to height and so forth. Do you recall that?
Yes, I do, yeah.
And do you, for the reasons you expressed in your evidence, particularly at 9.4.10, if you have that on page 49, where you talk about density and urbanisation and the settlement edge, do you stand by what you say there in supporting your position?
Yes, I do.
And when one looks at the PPG illustrative features for Purpose A, the strong contribution, is it right in your view, as you said in your proof, that this area is free of existing development at the moment, the appeal site?
That's correct.
Is it also right in your view to say its appeal site is adjacent or near to a large built-up area?
It is, yes.
And do you stand by your view as to it being an incongruous pattern of development?
I do.
And in light and the woodland stuff, your view, do you think that existence of the woodland precludes the contribution being strong?
No.
All right, thank you. Now, in relation to Purpose B, you were taken again to the wording, and you were focusing on those two indents, the substantial part of the gap, and you asked some questions about substantial, and the second indent likely to result in loss of visual separation. Now, in your evidence, you referred the inspector to the decision by an inspector in the Lancaster case relatively recently for his note at Core Document 5.9, and you tell us in your evidence at 9. I don't think you're asked about this specifically, but it's relevant to this purpose. You were asked, you say in your evidence at 9.5.2 that inspector highlighted one shouldn't focus entirely on those points. One was entitled to take a broader view, looking at matters such as perception and topography. Is that what you've done when you've assessed?
I did, yes.
And taking those matters into account, I mean, I don't think it was suggested to you couldn't look at those matters, but taking those matters into account, do you come to remain of the view it's a strong contribution?
I do.
Yes,
yes.
Right. And I think you were asked about it forming a substantial gap, and you said, well, you accepted in physical terms it doesn't form a substantial part. But what about in perceptual terms? What's your view? Would it be perceived as forming a substantial gap or not?
I think it does, yes.
Right.
Yeah.
Okay, fine. Thank you. Good. Final couple of questions. Some issues relating to landscape and visual matters. You were asked in relation to character issues about value. It said, I think, that Ms. Brock has gave a medium value. I'm not sure that's right, actually. I can deal with that with her. But in terms of the differences between your assessments of high sensitivity or high moderate and others, can we just remind ourselves of your table, please, and your proof, your table 1. because, do you have that on page 27, it begins? And you'll see, do you have that?
I do, yeah.
And you'll see when one looks at some of the assessments of the appellant, this is the LVIA at this stage. For example, woodland trees, it's assessed by CSA as medium to high in terms of sensitivity. And then if you look at site character, CSA, when you look at your table, they break the site into two parts, don't they? Is that right?
That's correct,
And
yes.
Because you've recorded in your table, as we see on page 29, they assess part of the site as being medium to high sensitivity. I think that's the woodland, the Theobald's Wood.
That's correct,
Right.
yes.
And the other part medium to low. Yeah. So is it right that CSA identify some elements of the site as land estate receptors as being in the high sensitivity category or high to moderate?
Because it was the woodland element of the site is a local wildlife site.
Good. Thank you. Final question. You asked about significance, and significance as a phrase to use it. Is that relevant to this kind of case in your view, or more relevant to EIAs, or was it relevant
It's
here?
relevant to EIA.
Yeah.
Yes. It's an extra step when you consider which effects, whether they be moderate, significant, what level of those are significant, and that needs to be agreed as part of an EIA process.
Yeah.
So it's very difficult to make a judgment on that here.
I mean, as I asked you, Chief, you seem to be a long way apart in this Brockhurst finding on significance, perhaps less so on substantial adverse effects or moderate.
Yeah, yeah.
And that remains the position now, does it, on your departure on significance from her?
That's correct, yeah.
All right. Good. Thank you. So those are my questions. So do you have any questions you'd like to ask the witness? Thank you. Then that witness has evidence done.
So actually about 5:15, so congratulations to the parties for bringing that in to time. Tomorrow we'll move on to Rule 6 party landscape witness as well, perhaps even the appellant as well. Does anyone have any housekeeping items for
No,
me?
so it's just on the timetable, if I may. You'll be conscious there are some points, particularly when we get to the 106, which are not being run by me, they're being run by the county, and they've put in some submissions, I think particularly on the education facilities, I think. And I understand that someone will be attending, or intends to attend, and at the moment, I'm going to relay the message to them, if I may, that might be Thursday or it might be Friday, but I didn't want them to be. Is that fair, sir? I mean, if they can't make either of those points, I'll ask them to get back to me. But that, I think, is probably where we are. I just don't want to, unless we really race ahead. But we can perhaps review it again. Review it again tomorrow afternoon. Probably Friday.
Friday, I imagine. I don't think. Okay.
We'll see how we go. But that's what I'm going to report to them. I don't want to be. It's really just protecting my back from the county if they say, "What on earth are you talking about this or that?" But I think that's what I'm going to say to them.
Yeah. Okay. No, I understand that. I appreciate that.
Sorry. Jackie, turn your mic off. That's it.
Thanks very much. I agree with that. I think that it's a programme's likely to run as you've put it, sir, but you never know, because I think tomorrow we've got a fighting chance of getting on to Mr Stroud in the afternoon, at least in chief. And if there was a possibility of getting on to the 106, maybe not conditions, but the county to come, because there's some ins and outs to that, and it would be hugely advantageous, I think, for everyone, including you, sir, if we had that discussion before Thursday night and could make sure that it was all in writing. It might be a bit more difficult on the day, hearing them in the morning and then doing the closing in the afternoon on that. So making sure they're available is a great idea, I think.
Yeah, I mean, it's just because although it's an important point for the inspector to have, it's not a point I'm running or making submissions on, it's for the county, and so if they're not here, it can't be done. Thank you.
So just on that, Mr Warren, you think there's a fighting chance we might get to go at least talk about the planning obligation on Thursday afternoon?
I think there's a fighting chance of that, so yes.
Okay. Yeah. If you can convey that on, I think because it gives you more time to deal with that as an issue, that is at least helpful. Yeah, okay. Thank you. And again, the timing that's suggested, just to give us a little bit more wiggle room, starting at 9:30 tomorrow. Okay, everyone happy with that? Horace, right. 9:30 tomorrow morning. We'll adjourn then until 9:30 if that's everybody sorted there. Happy? Okay, thank you very much for your contributions. See you tomorrow.